As far as the call of telephone logs is concerned, that ran from the 10th to the 17th of August 2021. And what they did was indicate the nearest cell site which picked up the respective calls. And they did show, again, when Palmer was receiving or making a call, likewise Campbell, likewise the deceased, and likewise Chow. I should say, and Chow. There don't appear to have been, as far as I can make out, any texts from Chow. So that's the nature of JS2. But the only really incriminating material in JS2 as such are the text messages passing to and from Campbell shortly before and shortly after the killing. I say incriminating, of course, those between the girlfriend and the deceased are incriminating, but they are not from Campbell, they're from the deceased's phone. I think I've given you the references where you can find it all in the summing up. We don't summarize all of it in the case, but we do summarize quite a bit of it in our case. We have tried to get hold of I think it was Exhibit 10. There are some difficulties getting hold of Exhibit 10, that's all I can say. I have seen what we believe to be Exhibit 10 in relation to the texts. I was handed another exhibit, which plainly was the unedited version in relation to telephone calls. So we haven't put that in. But we can make available what I believe to be the exhibit in relation to text messaging.
And did the judge sum up in relation to the cell site evidence?
No, not really, apart from what you've just shown. I think it's fair to say not much appears to turn on the cell site evidence. I will address you later as to why I say very little turn on it.
Thank you. Can I say, from the appellant's point of view, one of the reasons for, in one sense, perhaps not drilling down into the details of JS2 was for two reasons. Firstly, the clear position of the Crown, as I say, which is to rely on JS2 as being part of the reason why they argue that proviso should be applied in relation to the jury. That we would submit is a clear indication of the potential importance of JS2. The other is that, as I've already indicated, the clear indication is that this was a case where, in particular, the only direct witness, Mr. Chow, was someone who appears to have been regarded as unreliable by the jury on the basis of, given the acquittal I've already drawn attention to. And that demonstrates the potential importance of the technological evidence. Can I go back, though, to the point that the reason I was talking about what was being argued below and drawing attention to the fact that there was no debate about the, it's clear, it was accepted that there was an argument that JS2 should be not admitted in light of the Charter, and in particular the breach of the Charter. The reason I draw attention to that is because effectively what the Crown does is argue that what is now being put before this court is a new point. That's a part of the Crown's response. In summary, we don't accept that is right for these reasons. Firstly, as I've already indicated, it is clear that the issue of a breach of the Charter was before the trial judge. That's accepted. Now, the arguments may be different, more nuanced, may rely on authorities that weren't being raised at trial, but that doesn't mean that the issue wasn't before the trial judge. That relates to this matter is premised on there having been a breach of the Charter. all the way through, and I can give you the references in a moment, all the way through from trial court up to Court of Appeal. The way in which this matter has been dealt with is on the basis that it appears to be accepted that there is an issue in relation to the Charter, and the question was, what implications should that have? And that's why the Court of Appeal then, we would say properly, referred a question about the approach that should be adopted by trial courts to evidence that's obtained in breach of the Charter. And so we don't accept that this is a case where we're prohibited in some way from arguing what we're arguing. We're arguing the same argument, the same issue that was raised at both courts below, albeit perhaps slightly more nuanced. Now, in terms of the nature of the breach, because our case accepts that there is no automatic rule that a breach of the Charter will inevitably lead to exclusion of evidence. It is a more nuanced argument than that. It's important in one sense to be aware of the nature of the breach. And in one sense, the starting point in our submission in relation to that has to be the legislation, the section 16. Yeah, section 16 of the Interception of Communications Act, which is at 6277, the relevant passage, section 16, the Act, and that is section 16.2, and it is not a complex piece of legislation, which is probably a virtue. It requires a designated person to make a request, and it requires an authorised officer to receive the material. Designated person is defined, section 16, page 6276, the preceding page. Designated person means someone who's prescribed by the minister. Section 2 defines what is an authorised person, authorised officer, and that's at 6257. It's a number of specified officers within law enforcement. Two other features of this legislation that are worth noting. Firstly, if you go to 6279, section 17 links compliance with section 16 to admissibility of evidence. And section 4 demonstrates in one sense that what this act is consistent with the terms that of the legislation that I've taken you to already, because section 4 is concerned with warrants essentially for interceptions. And what that demonstrates in my submission is what this act is about prescribing safeguards in circumstances where what the Jamaican state is and what Jamaican law enforcement in particular is seeking to do is interfere significantly with the rights of individuals to privacy. So it is a piece of legislation that's intended to put safeguards in place and clearly requiring officers of sufficient seniority essentially to authorise gathering of data. It is an important part of seeking protection, of protecting the rights of privacy. Now, in this case, Corporal Brown was the officer who made the request, as I'm sure you've picked up. He said expressly that he was at page 1631 of the bundle, line 19. He said expressly that he was familiar with the Act, and that was hardly surprising because his whole role, as he gave, which he, according to him, when he gave evidence, was essentially to make requests under this Act. And you see that at 1574, line 5, on line 5 to 13. Now, there's been an issue about what he was cross-examined about, and that's raised by the Crown in their case. He was cross-examined about his knowledge and a compliance with Section 16. If you go to 1632 in the bundle, he expressly said that from line 24 on until line 4 the following page, that he knew that there needed to be compliance with Section 16, and he believed that the notice that had been sent to Judicial complied with that. Now, that is in one sense a slightly surprising answer, given what he says almost immediately afterwards, because he was then cross-examined about the need for a designated person. And if you go to 1635 from the top of the page, he recognises that Section 16 requires a designated person. He recognises that he wasn't designated. He says that twice, in fact. I'll just give you the reference. He also says it at page 1641. And so on the face of it...
He's not designated, but he is authorised to receive.
He claims he's authorised to receive. I think it's the Court of Appeal found he wasn't authorised to receive, but he...
The judge accepted he was in the voir dire.
Well, I'm not sure the judge actually expressly ruled on that, but certainly the Court of Appeal was of the opinion by the time that they've got no evidence that he was an authorised person.
Well, did they get other evidence other than that was produced in the voir dire before the judge, where this matter was fully explored?
Well, the problem, and if you look at the evidence, there's his assertion that he's an authorised person, but he clearly doesn't come within the terms of the legislation, and there's no evidence there was no evidence that I can find that indicates how he gets authority when the terms of the legislation are clear. So that's why I assume the Court of Appeal said what it said, because on the face of it, it's difficult. Although that was his answer, he clearly doesn't come within the definition, and there's no evidence to explain how authority was in fact given. So that's why I think the Court of I don't know, slightly speculating there, but that would be a good reason for the Court of Appeal to say what it said. But it may not matter, because in one sense, there was non-compliance. There clearly was nobody disputes there was non-compliance, and that may matter to some. I suppose the way which it may matter is it may go to how serious the breach was. But I mean the clear problem here in our submission is Corporal Brown is saying, and I'll give what I understand may be his answer to this in a moment. Does take you to it. Corporal Brown is saying, I know about Section 16. I know you need a designated officer. I know I'm not a designated officer, effectively. So on the face of it, that's a problem. Now, what he does suggest is if you go to 1643, and this is all just to make clear in the course of cross-examination, which is clearly intended, we would submit, to determine why this breach occurs. And 1643, 2022, line 22, not 2022. Corporal Brown indicates that there may have been, that others may have been designated.
We names it.
He names them, yes.
922.
Yes. He names two officers, ASP Pascoe and Inspector Williams, as potentially others who may have been designated. But he accepted, if you go on to 1646, that he did not know whether or not they'd had the benefit of an affirmative resolution. And you will remember that the terms of the legislation are clear, that you need an affirmative resolution. And he accepted that he, in one sense, he needed to rely on them having that authority, because he knew, he accepts at 1652, that he knew the request was not from a minister. And so you have on the face of it, Corporal Brown saying, I know what the legal obligations were, but essentially I've assumed compliance with them. And you see that reference to assumption, that's his language, not mine, essentially, at 1653, lines 13 and 14. And that, in our submission, suggests that this isn't, that there is at least a degree of negligence, essentially, here, in the sense that this is someone who understands it's his job, he understands that he is subject to legal obligations. He doesn't check effectively compliance with those legal obligations.
Doesn't he at some point say that advice had been taken?
That's, I think, if I remember rightly, there is a reference to that. I think that may be the Digicel witness from memory. I'd have to double check that, because but I think it was there was reference to advice, but I think that was the Digicel witness.
Perhaps we can come back to that.
Yes, but I will. Yeah, my learned junior has confirmed my memory is.
Thank you very much.
I'm always just a little cautious about saying things on my feet, but I think that's right. Yeah. It was the Digicel witness. And of course, the other factor here, which is something the Court of Appeal highlights, is that the Court of Appeal had already, by this stage, by the stage of the investigation, not the stage of the trial, but by the stage of the investigation, made clear that there was that what the terms of the ICA were, the legislation were, in a judgment called Phipps. And the Court of Appeal point this out at 137. So it wasn't as though, I mean, the problem with taking advice was that that might have explained an initial failure to comply. But if you look at 137, which is 5828, they highlight the fact that Phipps demonstrated a flawed approach similar to that adopted by Corporal Brown. And that raises the question of, in one sense, even if Corporal Brown is effectively the relatively low-ranking officer who perhaps hasn't picked up the latest Court of Appeal judgment, why action wasn't taken by those in command of him? And that's one of the things that the Irish Supreme Court have emphasised when looking at responsibility for compliance with constitutional rights. It's not simply the person who's on the ground that you need to worry about. It's what happens higher up the chain and why the system essentially was operating the way it was. I mean, this was a situation where the Jamaican police had been told in Phipps, your process is wrong. And yet there was no evidence essentially explaining how you then had Corporal Brown making the same mistake or a very similar mistake. Now, the Crown argue that it wasn't put effectively that the police, or indeed Digicel, acted negligently. A few things about that. Firstly, it was the Court of Appeal themselves who essentially pointed out the non-compliance with Phipps and the issues that arose in relation to that. Secondly, but perhaps more importantly, The word negligent wasn't used in cross-examination. I accept that. I can't find any reference to that. But the questioning clearly focused on the actions, whether effectively the actions of the police demonstrated that they were disregarding their legal obligations. What the questioning was focused on was how Corporal Brown had been in this position when the provisions were clear. Thirdly, in any event, I'm going to come on to make the point, based on case law, particularly Mohammed, that the burden was essentially on the prosecution to show to explain essentially why there'd been non-compliance with the law. And it should be, if you, 1966.
There's no reason to think, had Corporal Brown been designated and authorised, there's no reason to think that this material would not have been provided. There was no substantive reason why that material wouldn't be provided, is there? I'm just asking.
Well, the way in my submission to approach that, and can I, in one sense, take issue with the way the question's phrased, rather than, and I will answer it directly if I can as well in a moment, but I'd take issue with the question. In our submission, if the Crown is going to say it doesn't make a difference, it has to adduce evidence of that. Now, in a case like this, the role of the minister and anyone who's been designated by the minister is important, because it is essentially intended to act as a check. It's intended to ensure that the police can justify a substantial interference with privacy rights. Now, the way in which you potentially it would have been potentially open to the Crown to call, for example, the minister or someone they designated and say, who could have said, I'm the designated person, I've looked at this, there was a good reason for making it. That material wasn't produced. So one simply doesn't know that. So
the investigation of a very serious criminal offence targeted at people alleged to have been involved in that very serious criminal offence would have justified disclosure of this material?
Well, you need a sufficient, I mean, you can't, because of the privacy material,
Okay.
you can't.
You don't accept?
I don't accept as a matter of principle
Okay.
that you need enough, you need a good basis for believing that evidence may be relevant. Of course, I mean, the whole point of the legislation, it seems, we would submit, is to strike a balance. So it's to recognise that there may be circumstances in which the evidence will be of value and to enable a route by which it can be obtained, but restrict those circumstances by putting checks in place. So that's why we would submit that on the material available, one simply doesn't know whether a designated person would have. And just one.
Whether a designated person would have made the application.
Sorry, whether the designated person would have authorised it, yes.
Well, the designated person doesn't authorise the notice to.
Yes, because that's that in one sense the author. My lady was asking me the point about designated officer and authorised officer. And in one sense, the designated officer, in a very real sense, the designated officer is the more important safeguard because he or she is the person who gives authority,
Yeah.
and they're the one who needs to ensure that there's a sufficient justification. I assume the reason why an authorised officer is needed to receive the material is to make sure its privacy is subsequently protected.
Yes.
But the authority is given by the designated officer, and they're the person, in one sense, who is perhaps the more important safeguard.
Well, how do you square that with your submission about the importance of the material?
Well, when we look at the material, was important, but that doesn't mean at the time the application was made there was justification, because obviously when making the application you don't know what there's, as far as I'm aware, there was no reason to believe that there was knowledge essentially of what that material would show. That doesn't mean it wasn't justified making the application. It may be that the officer had sufficient information to demonstrate that there was reason to believe there were telephone communications. But we now know the relevance of that material. The question that we don't know in my submission is whether a designated officer, knowing what was known at the time the request was made, would have been satisfied that the justification outweighed the interference with privacy. And that's an important safeguard. That's clearly why the requirement for a designated officer exists. It's to stop fishing expeditions. It's to ensure that there is a proper basis for making the application. So that's, can I just draw attention to one other reference in the material about this, which is going back to the point I made about the need to, in one sense, have material about the system and how Corporal Brown wasn't effectively given clear directions as to what he needed to do with. If you go to 1966 of the authority, not of the authorities, of the electronic bundle, line 10, there is a submission there made by the Crown, albeit one that's made apparently without an evidential basis expressly for it, because no evidence was called in relation from a commanding officer, as far as I can see. But in support of the submission that Corporal Brown was acting in good faith, the reference was essentially that this procedure had been dictated to him. Now, that raises the question, that's why, in one sense, we submit, it's striking that there was no evidence about the command structure, how this system had been allowed to remain in place, despite the clear terms of Section 16, and despite the clear terms of Section 16, and despite the judgment of the Court of Appeal. And the Crown makes the point, or argues, essentially, that the defence didn't argue that Corporal Brown's acts were, they didn't challenge the submission that Corporal Brown's actions were in good faith. Firstly, we would submit that making whether or not the actions were in good faith sets up a false dichotomy. Essentially, there isn't in our submission a simple distinction between actions that are in bad faith and all other actions. The reality is that breaches of constitutional rights, such as those in this case, fall on a spectrum. For example, somebody can act in good faith but still be negligent by simply not paying sufficient attention to their legal obligations. They can act in good faith, but there can be a failure by those in command of them. Secondly, the submission that is highlighted by the Crown about good faith was essentially an argument that good faith was irrelevant to the breach of the legislation. It wasn't essentially a submission about how the court should approach the consequences of the breach. In terms of the consequences of the breach, the submissions, as I say, were pretty clear that there was an argument, essentially, that there'd been a breach of the Charter and that should lead to the exclusion of the evidence. And the trial judge recognised the significance of arguments of the breach of the Charter. The charge, if you go to 2237, bottom of the page, lines 23, the trial judge indicated he recognised the force of the arguments there'd been a breach of the Charter, apparently accepting that there'd been a breach of the Charter. But at 2240, at lines 13 to 20, essentially, he cited Khan, and in particular, 2240, he cited Phipps, which is the Jamaican Court of Appeal Authority, which indicates that...
I think he cites Khan on 2240.
224, well, right at the bottom he cites Khan. He cites Phipps before Khan. Sorry, I was misreading my own notes. I'd gone to 2241, and that's what was slightly confusing.
Yes, I see. 2239.
Yeah, he cites Phipps. He then cites Khan. And what he does at line 20, rather, at 2241, is he indicates that essentially that the breach of the convention does not mean the trial is unfair. And applying Phipps, if you then go over to 2242, line 17 onwards, he indicates that the issue is relevance and not how the material was obtained. So on the face of it, particularly at 2242, what he's doing, applying Phipps, which itself goes back to Khan, which we submit is the wrong approach, he directs himself that the only issue really is the relevance of the material. It doesn't matter that it was obtained in breach of the Charter. And that's, we would submit, the approach that was adopted by the Court of Appeal as well. If you go to 5833,
sorry, page?
Page 5833, 147. You see the application of King and Phipps, and then if you go on to 5836, top of the page, which is the end of paragraph 150, the judge adopted essentially the correct approach. The indication is that the judge adopted the correct approach applying King, and that led to the rejection of the arguments about the Constitution. And so the Court of Appeal proceeded on the basis that there was a constitutional issue raised, a charter issue raised, but rejected it given the application of King and given the application of Phipps. And we submit that is a misdirection, and that had this been approached properly, given the evidence I've taken you to, and in particular the absence of evidence to explain essentially how it was that Corporal Brown, despite apparently being aware of his legal obligations, didn't ensure that there'd been compliance with those legal obligations, we submit that in those circumstances that the evidence would have been excluded. Now, the reason we submit it should have been excluded is this. Firstly, it's important to start with the Constitution and the Charter. And the Charter in our submission, the reason for that is that we submit, obviously, that it's important to look at what the Charter itself says to see what approach essentially should be adopted to breaches of it. And the charter is electronic bundle 6248.
6248. Thank you.
Just before you move on to this, are you submitting that the approach in Phipps and King is that one is not concerned at all with how the evidence is obtained, that there's no discretion?
I'm submitting this, that King and Phipps, certainly the way the judge understood this, and I wouldn't disagree with this, is concerned ultimately with the impact on the fairness of the proceedings, not how the material was obtained. Now, there are circumstances possibly where how the material was obtained may have an impact on fairness. I mean, if you torture someone, that would probably have an impact on fairness. But the critical difference between that and Muhammad, which is what the approach of this court to written constitutions, is that what Muhammad does in our submission is recognise that there is a significance in a state incorporating rights within a written constitution, effectively elevating those rights as being ones that have to be given particular weight, and that even in circumstances where perhaps there isn't an issue about fairness, what the court needs to do is balance the unfairness, sorry, not balance the unfairness, balance the nature of the breach against the interests of the state in admitting the material. And so the fact of a breach has to be given weight. And Muhammad recognises that that is a different approach to King. It expressly says that.
So do you not take into account the fairness, the impact on fairness as part of that balancing exercise at all? You just weigh breach as against interests of the state in disclosing?
Well, you can't, obviously, because you have a constitutional right. Now, I'm not arguing you can have an unfair trial, but the nature of what you can have in my submission, that I'm not saying you wouldn't take account of that. What you can have is a situation where the nature of the breach is sufficient on its own to justify exclusion. Because the nature of the breach...
Yes, no, I understand that, but I thought in answer to my Lord's question, you were saying you don't any longer, as a result of the Charter, have regard to the impact on the fairness of the trial.
Well, can I just slightly modify my answer? I was referring to Muhammad, and we obviously go one step further, arguably, by referring to the Irish case law. So we would potentially go a little further, and I'll come on to the Irish case law in a moment. But before I do, what I was trying to do, just to be completely clear, is draw a distinction between the King and Phipps approach, which is simply focused on the fairness of the trial and doesn't necessarily give any weight to the significance of the breach, and the Muhammad case, which does give weight, and very real weight, to the significance of a breach because of the importance of a written constitution. If I suggested that fairness wasn't a factor, then that was lazy language on my part.
So you accept it is a factor?
Yes. It has. Yes, I would accept under Muhammad it has to be a factor. Yes. Yes, but as yes, just to re-emphasise though, the critical point about the Muhammad case law is it gives weight to the inherent significance of a breach of the Constitution, and so it can lead to exclusion simply on the basis that there is a need to protect and vindicate constitutional rights, and that's the distinction we would draw. Going to the Charter, That's, as I think I indicated, 6248. I should say, we've used this unofficial version. I've had this issue before. There is, as far as we've ever been able to discover, there is no official version of the charter, of the amended constitution, including the charter. So you can find the legislation that includes the amendments to add the charter. You can get a version of the constitution that doesn't include the charter. This is the only version that we've ever been able to discover of the fully amended constitution. And that's why we refer to it, but it is formally from an unofficial source. There doesn't appear to be an official source which is for the constitution fully updated. The key provisions, firstly, to draw attention to, can I draw attention to section 13(1)(a) and C first? They are, well, the whole of section 13(1), really. The first point I wish to make is that section 13(1)(a) imposes a positive duty on the state to promote observance of human rights. Now, that is, in our submission, a demanding standard, and it's not, it goes beyond a mere obligation to comply with the human rights standards contained in the Charter. And it's part of the context in which admissibility questions should be viewed. Obviously, a key way of promoting observance with human rights is to ensure that non-compliance with the Charter has consequences. 13(1)(c) I draw attention to because it demonstrates, and there are other features of the Charter that reflect this, the fact that Jamaica's approach to human rights goes beyond, in one sense, a European approach, because it applies to all persons. The obligations under the Charter apply to all people. That was, looking at the debates, a positive decision, and it demonstrates a key feature, and I'll take you to some material that makes good this submission, of the Charter, which is a desire, essentially, to enhance rights, reflecting the fact of Jamaica's independence. Section 13(2) then indicates that effectively the rights that follow in section 13 have to be complied with, save as may be demonstrably justified in a free and democratic society. Subsection B makes it clear that no organ of the state shall take action which abrogates, abridges, or infringes those rights. That's important for a couple of reasons, we would submit. Firstly, it makes it clear that there is an obligation on the courts, because as an organ of the state, essentially, to ensure that those rights, the rights that are incorporated within the Charter, are not abridged. Secondly, when read then with subsection 3J Roman 3, which is about the privacy of communications, it explains why in our submission it is clear that a failure to comply with the relevant legislation, the Interception of Communications Act, is a breach of the Charter. And the reason, quite simply, is the legislature has decided effectively the limits of what are justifiable interferences with the right to privacy by imposing a procedure that needs to be gone through before there can be interferences with that right to privacy. And if an individual such as Corporal Brown goes beyond that those restrictions, in our submission it becomes clear that it can't be justified, essentially, because because, as I say, the legislature has set the limits. There's a sort of analogy we draw in our written case between the point my Lord Reed made in the Osborne case about how human rights standards are often in very general terms, and it's for domestic law effectively to fill in the gaps. And that's what we say the Interception of Communications Act does in this case. It is what fills in the gaps in a very general statement about the importance of the right to privacy. And that's why it's so important, compliance with it. And that's why in our submission it is right to, it's right that the courts below proceeded on the basis that there was an interference with the right to privacy. Now, one thing I should just touch upon is that the prosecution say, well, it's absurd, I think is their language, to argue that the constitutional rights of Mr. Chow or the deceased or his girlfriend were interfered with. In our submission, firstly, the approach to waiver will become clear when I come to jury rights, and in our submission there's no suggestion of waiver. But in any event, it misses the point. The whole point about the Interception of Communications Act is that in a modern society, clearly there is a huge amount of data held by all of us, held on all of us by people like communications companies. So there is a need for safeguards because there's no reason to believe that the material obtained was necessarily restricted to the deceased, his girlfriend, or Mr. Chow. All the indications are sort of indicated that it goes beyond that, and that's why these safeguards matter in our submission. Two other provisions worth just noting. Firstly, partly so I can avoid going back to them. Firstly, section 16 is the right to a fair trial by an independent and impartial court. Included within that, in the criminal context, at subsection 6G is the right not to be tried in your absence. That is obviously relevant when we come to the jury issues. It does have some implications, though, for the first issue, the admissibility, because in our submission, and we made this clear in our written statement of case, there are issues that potentially arise if the state breaches constitutional rights. There are fair trial issues, not least because, in one sense, the state then has an inequality of arms. It has used the powers it has in an unlawful way. The other provision we draw attention to, because it was touched upon by the trial judge sort of indirectly, is if you go to section 19.4, section 19 is essentially concerned with redress. And in particular, section 19.4 recognises that although the Supreme Court may, has jurisdiction generally to deal with breaches of the Charter to a point the judge made, there is a need, because redress has to be effective, for other courts potentially to exercise their jurisdiction. That links, we would submit, to the Brandt case, which we've referred to in our statement of case, which indicates it could be an abuse of process, essentially, to go to a court like the Supreme Court in the course of criminal proceedings. And we would say that the more fundamental point is that we can make about section 19.4 is it demonstrates the importance of redress being effective, and that in our submission is part of the reason why it's important that in appropriate cases evidence obtained in breach of the Charter is excluded. The Charter itself is, just to be clear, an unusual provision within the Caribbean, in the sense that, and this is recorded in a book that we've included in the authorities, page 8334, the Oxford Handbook of Caribbean Constitutions, it is essentially is that Jamaica is one of only 3 countries that has made significant changes to its independence constitution. In Trinidad, they're described as being cosmetic. In Guyana, they were concerned with the presidency being introduced. But in Jamaica, obviously, they were focused on human rights, and that's important. Jamaica is, as far as we can see, the only Caribbean country that has used independence essentially as a way to enhance human rights. And one sees the fact it was intended to enhance human rights in the Joint Select Committee report that led to the Constitution. If you go to 8213, this is the final report. There is a lengthy history, and we've set it out in our written statement of case. I'm not going to take you to it, and we've included the materials about it. There's a lengthy history of debate. It was a particularly long debate process. But the final report of the Parliamentary Joint Select Committee, it helps in 2 ways. Firstly, it makes it clear at 8213 that the Constitution was influenced by other written constitutions. And that's partly why we submit we're entitled, for example, to refer to the Irish Constitution, because it is a written constitution with similar features. Clearly, part of the aim of this process was to reflect developments in other states. More importantly, though, in one sense, one of the recommendations of the committee, which was adopted when the legislation passed through the Jamaican Parliament, it is set out at 8211, and that is that there should be a limited preamble reflecting the historic background, essentially, to the legislation, but most importantly, making it clear that what the legislation, the Charter was intended to do was produce, and I use these words because they're found in the preamble, was produce more comprehensive and effective protection of fundamental rights. So the clear intention of the Jamaican legislature when adopting the Charter was to enhance human rights. And that's reflected, I think, given time, I'm not going to take you to it, but we would refer you to the judgment of the Chief Justice of Jamaica in the Robinson case, first instance, but it is a judgment of the Chief Justice reviewing the significance of the adoption of the Charter, and that's particularly paragraph 203.
Page.
Sorry, it's page, yes, sorry, I should have given you the page. It's 6472, particularly, in fact, paragraph 6475N. And so there has been reference, it's not my term that I came up with, as to how the Charter is a Jamaicanized version of human rights, or it's a Jamaicanized approach to human rights. That's the context in which one should look at Muhammad. And Muhammad is in one sense, perhaps the least we ask for, or the least we argue for, in our submission, it reflects the current approach of this court to written constitutions. Now, Muhammad starts at 6301, and it was concerned with a breach. You see at para 11, it was concerned with a breach of constitutional rights resulting from the admission of a statement. Now, my learned friend says, essentially, just to address one point, that there is a difference, because what happened was in Muhammad was a breach of an express provision in the Constitution. He suggests there's a distinction here, but in our submission, nothing in this judgment indicates that there are different types of rights rights protected by the written constitutions. The fact of the matter is, either there was a breach of the constitution here or there wasn't. And as the question is, as the issue is identified at paragraph 11, the issue in Muhammad was the consequences. And the approach of the Court of Appeal, having rejected an argument based on US case law, essentially that there was an absolute exclusion, the approach of the Privy Council, essentially having reviewed a number of other judgments of a number of other courts considering written constitutions, is at 28 and 29 of the judgment, which is 6308. Couple of points that, well, just to highlight a few things. Firstly, and it's important given the facts of this case not to lose sight of this, at the top half of paragraph 28, the court makes it clear that if there's a dispute about facts, the burden is on the prosecution, essentially. And that was said to expressly include, for example, whether there was deliberate infringement of the rights. And that's important in our submission. Firstly, it clearly reflects the criminal standard of proof, but it does in our submission demonstrate in a case like this that if the Crown is going to say, for example, we could have obtained this material in any event, it needs to demonstrate that by evidence, essentially, as to from the relevant designated people. It also needs to explain what happened in relation to leadership in this case. Now, in terms of the test to be applied, the court notes, and I accept it expressly says this is in the context of Trinidad and Tobago, and that's important in one sense because obviously each constitution will have its own features, and as I've already indicated, Jamaica has this unusual feature of having adopted a deliberate, rather having amended the independent constitution and replaced that with a constitution which was intended to reflect a lengthy debate that had taken place within Jamaica. But it said in the context of Trinidad and Tobago, the approach is neither prima facie exclusionary nor prima facie inclusionary, but there is a need to weigh the interests of the community against the interest of the individual who's been exposed to an illegal invasion of their rights. Now, that is the context of then what follows in paragraph 29. And paragraph 29 is quite clearly a rejection of the King approach on the basis that there was a distinction to be drawn between constitutional rights and common law rights. And the reason it does that is because it indicates that it's of fundamental importance that a right is important enough to be contained within the Constitution, and constitutionality has to be given meaning. It shouldn't be meaningless. But it recognises that it's also necessary to consider the nature of the guarantee and the nature of the breach. The ultimate conclusion quite clearly is towards the bottom of the page, where the court talks about breach of a constitutional right being a cogent factor militating in favour of the exclusion of the confession. And that's the critical point in one sense. Going back to the question I think my Lady Simler asked me, the difference between the approach adopted in Phipps, the difference between the approach adopted in this case and Muhammad in our submission is quite clearly the fact that there is a need to consider the circumstances of the breach, and that breach itself per se is an important factor that potentially results in exclusion. And that is simply not the approach that was adopted by the Jamaican courts. Now, What we've sought to do, though, one of the issues that potentially arises from Mohammed, and it's one of the reasons why we've gone further in one sense and looked at JC, the Irish authority, is this. One of the difficulties in practical terms we would submit for a trial judge faced with a Mohammed argument is that, as with any balancing exercise, it can be very difficult to work out what weight should be attached to a breach of the Constitution, what factors are particularly important. And that's important because the temptation will always be to admit something because it seems of importance. There's an understandable reluctance to exclude evidence that potentially is important evidence of guilt. But the risk of that in the long term is that weakens the constitutional protections. Part of the point of Mohammed is that breaches should have consequences. If they don't have consequences, then the Constitution is undermined. And JC in our submission, one of the reasons why JC is important is because JC is based on similar idea. It's based on the idea that there needs to be a balance, but it's an attempt to give, in one sense, greater clarity. And the Irish Supreme Court expressly recognised the importance of clarity, because clarity means that the consequences of breaches are foreseeable. It means that the incentive essentially to breach is less. And that incentive, I mean, minimising that incentive is important. And it links in one sense, thinking about it, to a point, again, that my Lady Simler made to me a moment ago, which is, wouldn't this material in any event, paraphrasing, wouldn't this material in any event have been admitted? If it would have been admitted in any event, the question immediately becomes potentially, why was the shortcut taken? The police knew about FIPS. Why were they taking the shortcut if they could have obtained this material in any event? And that's one of the reasons why it's important to have clear guidance, because police officers in those situations need to understand what the consequences of their actions are. JC is in the authorities bundle it's in the bundle at 6641. And we submit it is of significance for a number of reasons. Firstly, the Irish Constitution, obviously, like the Jamaican Constitution, represents decisions by a relatively newly independent state as to what rights should be given particular protection. Secondly, and if you need a reference to this, it's in the judgment of Mr. Justice O'Donnell at para 97, page 6670.
Sorry, paragraph?
97.
Thank you.
Like the Jamaican Constitution, there is no express rule dealing with the exclusion of evidence. So what the court was trying to look at was what should be the implied rule, effectively. Now, what there is within the Irish Constitution, if you go to paragraph 4.18 of the judgment of Mr. Justice Clark, which is essentially the lead judgment on the approach to be adopted at 6686, there is an express obligation on the state to vindicate the rights of the citizen as far as possible. So there is a positive duty on the state, essentially, to protect rights, a factor that was relied upon. Here, we've already made the point about the language, particularly of section 13.1 of the Charter, which in our submission does impose, perhaps unusually in a human rights context, positive obligations on the Jamaican state to promote rights. Not only that, the Constitution includes a right to adequate redress. I took you to the provision, I think it's section 19. And it makes, sorry?
Redress for what?
For a breach of the Constitution.
Of whose? I might have imagined redress might be for the breach of the constitutional rights of the person who was seeking redress.
Well, yes. I mean, obviously that's an important...
Can anyone seek redress for a breach of anybody's constitutional rights?
Well, in our submission, anyone can enforce those rights because of the first point I made, which is about the need...
That's what you're seeking to do in these proceedings.
Sorry?
And that's what you're seeking to do in these proceedings.
Well, that's what, yes, because yes, because that, well, it goes back to the Muhammad.
It's not your constitutional rights that were breached on any view. It's not the rights of Mr. Jones and Mr. St. John.
That's, well, there clearly were issues in relation to one of the defendants, but as constitutional rights, because there was data in relation to one of them.
That's
but
Mr. Campbell.
Yes, Mr. Campbell. But the more important point in any event is that what this case law, I mean, what Muhammad it recognises is that, and this is made even perhaps more expressly clear by the Irish Supreme Court, is that if the courts simply ignore breaches of constitutional rights, then there is then the problem is that there's no incentive essentially on the state to comply with them, or there's very little incentive on the state to comply with them.
But Muhammad was dealing with a breach of the defendant's constitutional rights in relation to the obtaining of a confession.
It was dealing with a breach of his rights, but it was referring to but it was referencing the importance of breaches of constitutional rights generally. It was referencing the need to uphold the standards of the Constitution, and it goes back, if you consider the Jamaican provision, and it's why I started with it in one sense. Article 13.1 makes it clear that it's a positive obligation on all parts of the state, essentially, to promote human rights, to another way of phrasing that would be to not turn a blind eye to a breach of human rights. And that's, in our submission, what Muhammad is concerned with. I mean, if you think about the facts of this case, you had, on the evidence that you've got, the police were aware of their obligations following FIPS. You had individual officers who clearly were aware of their need to comply with Section 16. On the face of it, at the very least, they didn't investigate whether they were complying with Section 16. That, on the face of it, is a breach of the Constitution, and yet, on the approach of the Court of Appeal and the trial judge, that has no consequences. What's in one sense to stop police continuing to adopt a procedure which is clearly in breach of the Constitution. And that's why in my submission, the point that that's made by the Irish Supreme Court about there needs to be a sort of clear rules to ensure compliance with constitutional rights is important in my submission. Lord, given time, I'm going to try and speed up a little bit, but just to be clear, the approach of the Irish court is based on the features I've drawn attention to, and based on also the need for consistency in approach, which you see at 4.16 of the judgment. It's to set out essentially a clear set of rules that you see at paragraph 5.1 onwards of the judgment. They are said to represent, see paragraph 4.22, the need to balance the encouragement of enforcement agencies. It's at the bottom half of paragraph 4.22. The need to balance compliance with the value of the evidence, essentially. And that compliance is important in my submission because, as I say, if there's no weight given to that factor, there is nothing to stop the police continuing to effectively ignore the Phipps ruling, ignore their obligations under the legislation, and simply and breach privacy rights. Now, what the Irish court does, and I'm just going to go through it very quickly, is it sets out a clear set of tests that focus essentially on the degree of culpability. And that's, we would submit, consistent in one sense with Mohammed, because Mohammed recognises that the nature of the breach is important. What it does, though, is give greater clarity to the nature of the relevance of the nature of the breach by focusing on whether it was a deliberate breach, considering the role of senior officers at paragraph 5.9, and then also considering the potential significance of negligence or recklessness. Given time, I'm going to, because I want to spend plenty of time on the jury point, I'm not going to go into JC in any greater detail, but clearly, had the JC approach applied in this case, and we make further submissions in our written case as to why JC should be followed. In our submission, if the JC approach had been followed, the prosecution simply couldn't establish why there hadn't been leadership, essentially, that ensured systems were in place to avoid this. And that, at the very least, we would say is gross negligence.
If it had been followed, the prosecution could not have established what?
JC had been followed. The prosecution couldn't establish why there were systems in place, what legitimate reason there were for not having systems in place that ensured compliance with the Act, in circumstances where they'd already known that there was an issue following Phipps. And that, at the very least, we would submit is gross negligence. On the face of it, nothing appears to have been done following Phipps.
And you say that would outweigh the balance on the other side?
Yes, because otherwise, this is a case.
No, I understand. I just wanted to be clear.
Absolutely.
Outweighed the public interest in.
Absolutely.
Yeah.
That having been said, can I just add one qualification to that, which is that, I mean, in one sense, that the way in which that would potentially come into play would be if the court is considering applying the proviso, and there would be, in our submission, a potential, if the court was effectively thinking of rejecting on that basis, there would potentially be a value in having a retrial on that issue because of the value of, in one sense, the correct approach, the weight to be given to the constitutional breach might be an issue for the Jamaican courts. I'm not inviting I mean, ultimately, we submit the appeal should be allowed, but I'm just looking at, in one sense, a hypothetical example or a potential outcome, which is the court coming to the conclusion that the test was wrong, but the correct test would have made no difference. And I just would add a note of caution about this court. If it's a balancing exercise which has to give weight to non-compliance, question mark really whether this court's in the best position to assess that, given the importance of, in one sense, local assessment of the importance of the Charter. Can I then turn to the jury issues? A couple of preliminary points about the jury issues. Firstly, it is in our submission important to consider the jury issues together, in part, although we would say that any of the individual jury issues are sufficient for us to succeed, in part because if we're right that ultimately the question that this court has to ask itself is whether the fair-minded bystander would conclude there's a lack of independence and impartiality. Everything, to some extent, comes together because it's ultimately the final position that was reached. Was that verdict reached by a body but which, by the stage it was reaching its verdict, was independent and impartial? And that's a reason potentially for considering everything together. And they do link in one sense, because obviously one of the concern, you'll be aware that we make submissions about what's described at times as the second incident, which in one sense for our purposes is actually the first incident, which is the juror who was discharged. But of course, the juror who was released from the jury, one of the reasons that is of potential relevance is that seems to put pressure on the trial judge because he can't release any more jurors. And that's where he gets into this difficult situation where he knows that there is a juror who is attempting to bribe members of the jury, but they are allowed to continue to serve. Had they not been allowed to continue to serve, then the jury would have had to be discharged because of what had happened the second time.
So there were 3 incidents. I don't think you're making any submissions in relation to the first.
No, exactly. That's why I was saying.
So we refer to incidents 2 and 3.
2 and 3. I was going to use that language, but I was in one sense, in terms of what we're arguing, 2 is 1, but that's where the slight complication came from. But yes,
We better stick with 2 and 3. I think.
I wanted to make clear. I wanted to make sure everyone was using the same language in that way. Yes, absolutely. The second thing is that, in particular, in relation to the, and it's important not to lose sight of this when one gets into the detail, in relation to, in one sense, that the third incident in particular, the Crown puts very heavy weight on the directions given by the judge. Now, I'll make some submissions about those directions, but there is a fundamental problem in our submission by the time of the third incident. By the time of the third incident, the judge is proceeding on the basis that one of the jurors has attempted to bribe the other members of the jury. He's committed, potentially, a very serious criminal offence, and we in fact know he was convicted of that serious offence, and indeed he was arrested immediately after the verdict. While it may be right to assume for many jurors that they will comply with directions, if someone has demonstrated that they are willing to commit a serious criminal offence in the context of this trial, how can one then rely on their compliance with directions? It's unrealistic in our submission in those circumstances. And that's an important factor not to lose sight of, because it, in one sense, one can get wrapped up in the weeds of what happens, and it's important to go into the details, but one shouldn't lose sight of that overall problem, and it's a very significant problem in our submission, and it's just an insolvable one. It may have been deeply regrettable in Jamaica that a trial that has gone on for so long had to be restarted, but ultimately, if that's what's required to ensure that the trial is fair, then that's what's required.
There's nothing in Jamaican law that allows a judge to continue as judge alone without a jury.
No. And my lady's raised that point, and we've sort of thought about it. And obviously there is now in English law, it's a relatively recent development.
Yes, when there's jury tampering.
When there's jury tampering. And if jury tampering is a major problem in Jamaica, in one sense, that's the solution. My learned friend says, I'll come on to those submissions, you can't allow someone effectively to derail the trial. But if derailing the trial is a serious problem in Jamaica, well, there is a solution that's been adopted in England but hasn't been adopted in Jamaica. Now, the second incident, I'm not going to spend very long on the second incident. That happened, obviously, that's the incident that led to the release of one of the jurors. And it's summarised what happened at page 35, paragraphs 35 and 36 of the Court of Appeal judgment, which is at page 5786. And it occurred on the 6th of February 2014. Couple of features of it that I draw attention to. Firstly, it was addressed, and we do express a concern about this, and it's a problem that occurs in the context of the third incident. It was raised in chambers in the absence of the appellants, and we would submit there's no reason for that at all. No consideration appears to be given that.
Well, the source of the problem was thought to be one of the defendants.
Well,
so are you saying that it should have proceeded in open court in the presence of the defendant?
Well, the second incident, and I'll come on to the third incident, and I've got a separate answer to the third incident. The second incident, of course, is, and this is one of the problems about the second incident, is one doesn't actually know, in one sense, what the nature of the problem was, because the questioning came to an end when the juror became distressed, and the questioning in particular didn't address, and there's no material as far as I'm aware that addresses this, what was apparently said by one of the defendants to the juror's son, because she became distressed at that point in time.
Maybe the judge didn't go as far as he should have done in the questioning, but my question relates to where it should have taken place, whether it was in open court or whether it was in the judge's chamber.
Well, there's a strong, I would argue that current practice generally is that there is a strong presumption in favour of it being in front of the defendant so that they can contribute. If there is a particular concern, I accept that you can question in the absence of the defendant, but you have to here, part of the criticism is, in one sense, it just seems to have been assumed it wasn't going to take place. It's not clear what the evidential basis for that or what the reasoning was.
Well, there was a particular problem here which was thought to have emanated from one of the defendants because he'd seen the juror in the prison.
Well, he'd see what had happened. Yes, but I mean that on its face is not something that's he's to blame for. I mean, on the face of it, it's not his. I mean, he appears to have been attending the visits legitimately. There's no suggestion that he'd sort of.
The juror's concern was about a threat to her son.
Well,
a possible danger to her son.
Well, exactly. But that's the point in one sense. As it was expressed, it was about danger to her son. Because of the way in which the questioning was stopped, it's unclear whether there was a threat to her son. And they may be distinct in the sense that if there's threats being raised, well, maybe you can hold the questioning in the absence of the defendant, maybe. But of course, the other problem is, in any event, it's not as though this material is being withheld from the defendant per se, because their lawyers will go, but there's no obvious, they're going to know this information potentially because their lawyers will potentially feed back to them. It's just they're not there present, able to give instructions as the matter's being investigated.
Doesn't the bench book say that it should take place in chambers in those circumstances? I'm going to come to the bench book. I can't specifically remember that. I was going to take you to the bench book. I can't specifically remember off the top of my head what the bench book says, but.
Can I just ask, sorry to interrupt.
Yeah.
When you talked a few minutes ago about current practice, and when you're referring now to the bench book,
yes,
are you referring to Jamaican practice and a Jamaican bench book, or to English practice?
I can't remember what I was referring to as current practice, but I accept the point. I need to be careful to distinguish, albeit, can I make this point, that the Jamaican bench book, which I accept, and I was going to make this point when I come to it, the Jamaican bench book postdates the trial in this case, but what it does, which is why we've submitted it's of some relevance, is it makes 2 points clear in one sense. Firstly, it makes extensive reference to English standards, recognising that, perhaps unsurprisingly, given that the Jamaican courts apply the fair-minded bystander approach, there is no basic reason to distinguish between English and Jamaican cases. But secondly, it bases what is said in the bench book, unsurprisingly, on historic case law. So it seems to be it's not attempting to set out a new approach. It's on the face of it, it's seeking to consolidate existing principles. So that's why, just to be clear, the Jamaican bench book we would submit is of relevance, despite, as I say, I accept, well, that's why we say the Jamaican bench book is relevant, despite, as I accept, it post-dating the trial in this case. And that's also why we say we can refer to English authority, because clearly
never be dealt with in chambers in this country.
Yeah. Yeah. Just to be clear, and just because it is of importance, I think, probably to my lay clients, as I say, their understanding was effectively the primary allegation was that there was an accidental contact between defendant and mother on a visit. They don't obviously accept there was any threat made, and that, as I say, is not the evidence on that is.
I'm not suggesting there was a threat.
Yeah. Just also to be clear, because I've looked it up in the moment, I can't see in the Jamaican bench book a reference.
Well, I found it. It's paragraph 7.
Yeah. Sorry.
It's in paragraph 54 of your case.
Okay, I'm sorry.
7, it says, however, if there's suspicion about the defendant's conduct in the irregularity, then the hearing should take place with all parties represented, but in the defense.
Oh, sorry, yes. No, I found it. Yes. Yes, but I mean, in one sense, that's the difficulty here, is that one of the problems with it, which we haven't particularly, well, we have sort of raised, one of the problems here is, of course, that the way in which this would play out in England and Wales generally is you would have a clear record of what the juror was saying, because they would produce a note. So they would say, potentially in this case, in terms of the jury, the note to the judge, they would potentially say, my son's been threatened. That might have one consequence. They might say, I'm just a bit concerned that one of the defendants saw me at a prison visit, and I'm concerned that might have implications for my son, or something like that, which is a different, because that's not alleging misconduct. It's a different reason for potentially being disqualified. But you'd have a clear record early on, and so the judge would then be in a position essentially to invite submissions in the presence of the defendant. There's no reason why the defendant wouldn't be aware of that note. They'd be entitled to be aware of it, as to where and how the questioning should take place. But of course here, it was much more informal as to how the issue was raised. And that seems to have led to just the judge adopting the approach he did. And that is one of the complaints we make, to emphasize this, is that because of in one sense, the informal way in which a lot of this was dealt with, there isn't a very clear record of how certain key acts were taken. And I'm particularly thinking then, in relation to that, of the role the forewoman then takes in terms of sort of reassuring the jury. And going back to this incident, probably more important than the point I just was making, which was that this was in the absence, is that if you look at going back to paragraph 36 of the Court of Appeal's judgment, one of the things that happened was that the forewoman indicated that she would soothe everyone's mind, I think is the language used. That that is, in our submission, quite clearly not the same as giving a helpful direction, partly because it goes back to the point I was just making. There's simply no record of what she does. One doesn't know what she says. One of the reasons why a direction is so important in our submission is because it means there is no doubt as to what the jury are being told.
Well, he told, according to the Court of Appeal, he told the jury that she had a personal difficulty that meant she was no longer able to serve.
He told her that.
No, he told the jury.
Sorry, no, he told, yes, you're right. He told the jury, but the problem is that in one sense is part of a package. I mean, because what the Court of Appeals say before that, and they expressly rely on this, what he was told before, and the judge doesn't stop the forewoman doing this, is that she was also going to effectively, as I say, soothe everyone's minds. And the problem with that is that that's her, in one sense, giving guidance to the jury in circumstances where you just don't know what that is. Now, the other two problems.
What's the prejudice that you say flows from this first incident?
There are two other factors I was just going to draw attention to, which are perhaps more important in terms of prejudice. And the first is that because, in one sense, of the limited questioning, one simply doesn't know what the juror who was discharged had said occurred, whether there was a threat. And that's important because the other point we submit is that although the Court of Appeal at para 36 says that the forewoman had said others had not been told, what that seems to be based on, as far as we can see at least, is that if you go to the electronic bundle 4079, if you go to 4079, you see at 4079 the forewoman describing what occurred when she was told about this incident. She says she has a private conversation with the. She says she has a private conversation with the juror who had concerned the juror who was discharged. What she doesn't, on the face of it, ask of that juror, and what that juror isn't asked, is whether that juror has spoken to others. And that's in one sense the biggest problem here, and that's where that's the context of what then follows. To use the language that the Court of Appeal has used, and I've used based on the Court of Appeal, one has here a potential source of poison, to use the Court of Appeal's language. In other words, something that's potentially adverse to the defendants, which may or may not have been, in circulation. And on the questioning, because the questioning is limited, one simply doesn't know. You have the juror stopping at the point where she's about to describe what her son says. So we don't know what she says her son said. Was her son threatened? And one has the forewoman saying, I discussed this in private with this juror.
So at the moment you're at
4079.
79.
Sorry, the ending of the questioning, which is just the prior reference I gave, that's 4075, just so you've got the reference.
Just bear with me. Thank you.
And then 4079 is where there's the discussion, or where the forewoman between lines 6 and 20, particularly 15 to 20, she describes how she becomes aware of this. And she says that's in private.
So what do you say should have happened, ideally?
At the very least, because of the fact that there is, and I've identified where it should be, whether it should be in public or private, but at the very least, and this is the critical point because of this concern about poison, it was necessary to know whether the juror who was going to be discharged had spoken about this incident to anyone else other than the forewoman, and if so, what she had said, and in particular, whether she had made any allegations effectively that the defendants had made threats, anything really that went to the defendant's bad character.
There wasn't any suggestion, was there, that they had made threats?
Well, the problem was, if you go back, it's why I was drawing attention to.
They were simply on remand in the same facility as her son.
Well, it's a bit more complicated than that, my lord. If you go back to 4075, which is what I drew attention to.
Yes, I read it. She's obviously in a very emotional state and she's worried about her son. But
it's a bit more than that. In paragraph, if you look at line 5,
yeah.
Her son says that Kartel, who's one of the defendants, said to him, if ... Then Kartel said to him, if he ... Then it gets stopped. So she is saying.
I'm sorry, where are you reading?
4075.
Yeah.
Line 9, yes, line
9.
Yes, 9 is, yes.
Yes.
So she is saying, one of the defendants approaches my son and tells him, and we don't know what her son is told, because at that stage the questioning stops.
Yeah.
So that is in the context of her saying, I don't feel my son is safe. So the question is, in one sense, what is her son told? What is that the basis on which she thinks her son isn't safe?
Well, speaking for myself, I thought it was pretty clear from 14 to 17, where she says, Your Honour, the only thing I'm concerned about is my son's safety. They are there, he is there. They know him. And in particular, one of the defendants was on the same block.
Well, my lord, I don't want to spend too long on this, but that's got to be viewed in context. The question is, why does she Why does she think there's an issue with safety?
Well, it's pretty obvious, isn't it?
Well, there are, not entirely, in the sense that she's trying to recount something that her son is told, but she can't do it. I mean, so whether that is part of the reason why there's a concern about safety. But my lord, I don't, if you're not with, but my lord, we would submit that the critical thing here is that the forewoman is certainly told something about it. She gives some evidence about it. The question, you need to know, in one sense, whether there's a threat because she told that. But more importantly, in one sense, there is also others who may have been told, because on
so there was speculation that there may have been a threat and that the juror may have told the foreman about such a threat.
Well, my lord, but I would say it's more than speculation, on the basis that she is giving it. She gets very distressed when she is clearly saying that there's contact between my son and the defendant, and she gets distressed at that point. Now, so it's not entirely speculative in my submission in that context, because it's clearly distressing for her to describe what her son is told, and she finds herself unable to tell.
Or it may just be it's distressing that her son had contact with the defendant.
Well, it might be, but in one sense, that's exactly why it's important to get to the bottom of this, because you don't, and in one sense, it's the context of what then follows in the third incident, because you've got this problem of uncertainty about what prejudicial material the jury might have. Now, in terms of the third incident, can I move on to the third incident? That is obviously right at the end of the trial. It's described in the Court of Appeal judgment at paragraph 37 and 38. Now, the context of it, and that's one shouldn't lose sight of it, is that we now know that one member of the jury, consistent with what was being said at the time, was subsequently convicted of perverting the course of justice.
Attempting.
Attempting, sorry, yes, attempting, sorry. Because of the attempt, and yet, if this trial was going to proceed to a verdict, he couldn't be discharged, because it's quite clear you couldn't lose one more juror under Jamaican law. Now, again, the issue was raised in chambers. It was raised by the forewoman who was questioned by the judge. Now, it's important to recognise, in one sense, what she says, that some of the detail of what she says.
Oh, in fact, looking at this, we're told at the top of 4074 by the witness what this defendant said to the juror's son. Line 2, saw him and see him mother a juror.
Well, but what happens at 4075, it goes beyond that, because there is, the language used was, which is what causes her to get upset, was he was saying if. That has, I mean, that's the start in one sense of a threat. That's why we're raising it, because there seems to be a suggestion that if something happens, something else will happen.
Right.
So, and that's what she can't, and that's, as I say, the reality is that the judge could not be aware of what she in particular had said to other jurors. Turning then to, well, I've already gone to the third incident and paragraph 37 onwards of the Court of Appeals judgment, page 5787. Made the point, I think, already that, of course, one needs to recognise that ultimately the reason why this became an issue in part was because you couldn't discharge a further juror. It was raised again in chambers in the absence of the appellants. it was done by questioning the forewoman. She, at 5168, indicated that she effectively had contact with the other jurors, and to use her language, they had confessed to her. That's 5168. My notes are right. She refers to that. So she'd apparently carried out investigations and told them not to be swayed. She made it clear that she appears to, as I say, investigated it and discovered, according to her, that had taken place over what she describes as a period of time. And at 5172, she says that the 11 of the jurors had been spoken to, in other words, the full jury. Now, she said at 5168 that she told them not to be swayed. But of course, none of the other jurors were questioned, none of them were asked about whether they felt able to carry on.
Sorry, I've missed the point about all 11, you say, have been spoken to by whom?
By the forewoman.
Yes, I
You see that 5172, letter 20, line 20 rather, not letter 20.
Thank you.
11 of us. Yeah. She says 11 of us were spoken to. He spoke to 9 persons first. I mean, on the face of it, that would include the.
I was going to say, that must include juror 11, so it must have happened before juror 11 was just.
Well, on the face of
what she said.
On the face of what she says, and of course she talks about. I've indicated already. She talks about over a period of time. So the implication seems to be that this was not something that had happened that day, effectively. But obviously, because there's no questioning of the jurors, one doesn't have very much detail. Well, it doesn't have any detail about that. Individual jurors aren't asked, for example, how long they've been sitting on this. Now, nothing in the evidence is said, and this is important in our submission, about the source of the bribe. The judge may have assumed that the defendants were involved, or some of the defendants were involved. But there is no evidence of the source of the bribe. That it's speculation to suggest that the defendants were, or any particular defendant, perhaps in one sense more importantly, because each defendant and obviously has the right to be tried by an independent jury, whether any particular defendant was involved in the bribe. Now, the defence, in contrast to what happened in relation to the second incident, clearly did object to the matter continuing, but obviously what the judge did was remind the jury of their oath. Now, the approach of the Court of Appeal in my submission is important to bear in mind in relation to this when rejecting the appeal. At 5869, paragraph 238, Court of Appeal indicate that there was nothing to be gained from further questioning. And at worst, it could have required the discharge of the jury. That's important in my submission because one way we would submit a potentially paraphrasing what the Court of Appeal says is is that had there been further investigation, there is reason to believe that what could have come out was further material indicating how a fair trial was impossible because of the attempt at bribery. And that, we submit, if one's looking at the fair-minded bystander approach, cannot be right in our submission, because if there is uncertainty about what will come out, and there is reason to believe that what will come out demonstrates that there is a lack of independence, then the fair-minded bystander would, in our submission, be bound to say, well, in those circumstances, there has to be a real risk that there was bias, because who knows what the answers would have been. They may have been the ones that the Court of Appeal feared. Now, the respondent's answer, in one sense, seems to be primarily that there's no obligation to discharge the jury because anyone could bring a trial to an end then by simply offering bribes. They use the language of win-win. We don't accept that's right for several reasons. Firstly, we would submit, and this is perhaps the most important reason as a matter of principle, each of these defendants had a right to be tried by a jury, and they didn't waive that right. Come on to the case law in relation to waiver. In those circumstances, there is no basis essentially for denying them that right. But secondly, in our submission, which is equally important, and it goes back in one sense to the case law I was taking you to earlier about constitutional breaches, it makes assumptions which in our submission can't be made good in the absence in particular of any investigation by the judge as to any further investigation by the judge as to the way in which the bribes were offered, etc., because it assumes each of the defendants was involved in this in circumstances where there's simply no evidence of that. I mean, if you think about the question my Lady Simler put to me about what would now happen in England and Wales, of course, what now happens in England and Wales is because potentially there would be trial by judge alone. The rights of the defendants are still protected because they still have an independent tribunal trying their case. Now, we say that the way to approach what happened is to focus on the case law regarding bias. Two authorities, I mean, that case law is obviously extremely well known, but two authorities that I would draw attention to. Firstly, Lawal, which I'm sure the court is well aware of, was which was the UK Supreme Court applying Porter and McGill. The reason I draw attention to it is because it contains a little more detail about how the fair-minded bystander approach applies, and in particular, if you go to Authorities Bundle 6318. Two points I make about it is, having set out the well-known fair-minded bystander test, the Supreme Court, by letter C, makes it clear that public perception is key. And that's, in our submission, one of the reasons why it's open to this court to look at what happened in the round, because ultimately, if this is concerned in one sense with public perception, when the public look at this trial, in our submission, it is bound to have concerns because of the ultimate extent of the departures, essentially, from what is generally regarded as fair practice. The other point that we make is that in paragraph 15, the point is made that the fair-minded bystander doesn't come to this issue with a clean slate. They can look at analogous situations, etc., and rules in other contexts. And that's important in our submission because it does mean we can make reference to things like the bench book. The other authority that we draw attention to, which is an application of the fair-minded bystander test in the context of a jury, is the Brown judgment at 6330 of the authorities bundle. And Brown is important in one sense because it is an example of the approach adopted in the context of a bribery case. Now, the reason why I particularly focus on that is that if you go to paragraph 38 at the bottom of 6330, halfway through it, you see the court applying the fair-minded bystander test. But then, and this is the important thing, dealing with, and this deals with the argument the Crown put essentially about the defendants being, or the appellants being the author of their own misfortune, it rejects essentially the argument essentially that it was appropriate for the judge to rely on the defendants being the authors of their own misfortune, and the reason for that you see in perhaps expanded in considered in greater detail. If you go back a page to paragraph 31. Is that for that approach to apply, it must be either agreed or ascertained, can't be assumed. What the prosecution are essentially doing is asking you to assume that the defendants were responsible. It's entirely speculative, that. One other thing while we've got this open, so I don't have to go back to it. Unsurprisingly, we would submit, the Court of Appeal does consider the proviso, but rejects it fairly summarily. They do that, if you go back to the 6330, last line on page 6330, and the next two lines on the next page, recognising the fact that they had a strong prosecution case, but making the point essentially that there is a right to trial by
Impartial.
by an impartial tribunal of fact. I'll come on to the proviso in a moment, but we would submit that's unsurprising. If there is a right to trial by jury, and that jury must be independent, it's difficult to see, we would submit, how it can be right to then effectively deny a defendant that right by applying the proviso, because that will be a conviction without the evidence having been considered by an independent and impartial jury. Now, the Jamaican bench book is, first, given what I made about the point I made about the while is perhaps the starting point, and that's at 6790. And as I've already indicated, I accept this postdates the trial, but as I've said, it on the face of it, given its reference, given it extensively references earlier case law, is not on the face of it intended to be some sort of revolutionary approach to fair trials. It is intended, we would submit, to be a consolidation in one place of learning from both Jamaica and England and Wales. A lot of it is in fact from England and Wales.
Just before we leave the authorities, I'm surprised you've not taken us to Putnam.
I will take you to Putnam. All I was doing was to put in context. I wanted to, the structure, I should have perhaps explained the structure of my argument. The way in which I was structuring the argument was to look at the general test, the fair-minded bystander test, to set that as context, then go to some of the relevant practice directions, then go to the more specific case law, and I was going to come to Putnam at that point. So, Lord, Putnam is obviously perhaps of particular importance. It's obviously where I've made repeated reference to the spread of poison, and that's where I think it's Putnam from memory where that language of spread of poison comes from. That's obviously of key importance. Bench book is 6790, or there's actually some other passages of the bench book which are later in the bundle for various reasons, but the key passage for this issue is 6790, recognises at paragraph 3 the potential importance of discharging a jury for misconduct. Misconduct is footnoted to a case that makes it clear that includes bribery, then references the UK practice directions, recognising, we would submit, consistent with the fact that, as we've made clear in our statement of case, the approach of the fair-minded bystander is adopted in Jamaica as it is in the UK. I think they refer to it as the UK practice directions. Given my Lord's, given my Lord Reed's role on this court, I think it's more accurate to say the English and Welsh practice directions. But the point is there. More importantly, and this is really what I wanted to draw attention to, perhaps, is paragraph 5, making it clear that it's the duty of the judge to investigate whether or not a juror has been compromised, to enable the judge to make an informed decision. That is described as a duty, and in our submission, it's not surprising in light of, and it's one of the reasons why I went to the bias test first, in light of the bias test. If the issue is, and we submit it is there a real risk of bias in the mind of a fair-minded bystander, then if there is uncertainty, that means you can't rule out the real risk. The information essentially allows a judge to decide the extent to which there is a risk of prejudice and the extent to, and what steps need to be taken to address that. It makes it clear also that if jurors are discharged, they're entitled to an explanation. And perhaps more importantly, looking at the second incident rather, they may need a direction as to disregard comments from the discharged juror. And that's, if you think about the second incident, I've complained in one sense that we don't know whether there was contact between the discharged juror and others about this incident, and we don't know what was said because the juror the questioning of the juror stopped before she described the incident at the prison. Arguably, at least one way of doing that, which might have limited the poison, would have been to be more specific, essentially, about the need to disregard anything the juror might have said. And that's what happened in Taylor, in fact, we'll come to. The bench book goes on to recognise, essentially, that misconduct may require the whole jury to be discharged before verdict. It doesn't say very much about the circumstances, but certainly recognises that that is one way of potentially dealing with the issue of jury misconduct. So that in our submission is, in one sense, the Jamaican guidance. As I say, I accept it post-dates, but it's meant to reflect Jamaican practice. The other authority that's worth paying attention to, not least because it's been applied by this court in the Taylor case, was the guidance, because it is closer to the time of the trial, and as I've said, there's every indication that standards in England and Jamaica are no different. There is the guidance issued by the President of the Queen's Bench Division, Sir John Thomas, as he then was, in 2012, and that's at 8161 of the bundle. A couple of things that it adds that aren't necessarily clear from the Jamaican bench book is, firstly, it makes it clear that, in one sense, the first step, which can happen in open court, is to invite submissions from the advocates. Secondly, probably more importantly, it makes the point before that about isolation, that there may be a need to isolate jurors who are who perhaps have given rise to concerns. The reason I draw attention to that is not because it necessarily was clear that by the time the problems arose in this case, isolation would have made any difference, particularly in relation to the third incident. Obviously, on the forewoman's evidence, everyone in the jury knew that one of their members was trying to bribe them. The reason I draw attention to that is that if one thinks about the underlying purpose of that, it links to the point that's made in Putnam about the importance of isolating the poison. It is a recognition in our submission of the approach in Putnam that once something is going wrong, there is a real risk that information can spread within the jury, that, as I say, to use the language, poison can be spread.
I mean, on one view, you don't even need to go that far. I mean, if the judge was satisfied that one juror was trying to bribe others,
yes,
then it would follow that that juror was not performing his duties as a juror properly, as giving an impartial verdict based on the evidence, and therefore should no longer continue to serve. And if you get that far, then the trial has to come to an end, because under the legislation, in a murder case, there must be a verdict can only be returned of a jury with at least 11 members.
Well, my lord, in one sense, that's why, and I started this morning and then started the submissions back juries by saying, I'm going to go into the detail because obviously I want to take every point I can because I want to.
Yes, I appreciate that. I mean, I'm really making it's a two-level thing. I mean, on one view, once you have one juror who is clearly suspect, that's an end of it.
Well, exactly, my lord, and that's why I started making that.
And you don't even need to start thinking about what the impact might have been on the other 9.
Absolutely.
But I appreciate that's a further argument that can be developed.
Absolutely, but my lord, I deliberately started with that point because in one sense it is really important not to lose. And of course, my lord used the language of suspicion. We know he was now convicted of that, and that's the question for this court: was this an independent, impartial trial? And in light of what we now know, it's difficult to see how it could have been when one of the jurors and one of the jurors who had to be there was subsequently convicted of essentially being involved in the bribery. Well, look, I said I'd take you, my lords, to Putnam, and I will now, if I may. Yes, can I start at least by, because I'm just conscious of running out of time. Putnam's at 7577, and it is another bribery case. In that case, unlike this case, the bribe was not something that the judge was aware of until after the trial, but the judgment clearly contains important guidance on what judges should do if bribery becomes an issue during the trial. This was also a case where the bribery wasn't internal to the jury, it was an external approach. The critical point really, though, that comes out of this is that while the Court of Appeal, presided over by Lord Justice Bingham, as he then was, recognises that there may be circumstances in which a juror who is approached with a bribe can continue to sit, it seems to imply two things, several things. Firstly, if you look probably about 10 lines up from the bottom, Lord Bingham was of the opinion that the juror who is approached can only continue if there's not impropriety, and there needs to be a very emphatic direction. But given perhaps that reference to the need for impropriety, there is a particular concern, Lord Bingham makes clear, if the juror who's approached delays coming forward. And you see that at the bottom of page 758, that paragraph and the whole of that paragraph, because the concern is...
Sorry, 758.
Sorry, 7578. It's the last two lines, and then the paragraph goes over the next page.
Right.
And what Lord Bingham seems to be saying in those two, in that passage, is that if there's delay in a juror coming forward, that raises two very important questions. Firstly, is that juror failing to comply with their duty because they're not drawing attention to the bribe? And secondly, the longer the problem continues, the more there is a risk that the bribe will have unconsciously influenced. And that's the context of what Lord Bingham says at the end of 7579, the bottom, the last 10 lines.
It's also it's quite helpful, perhaps, just to see the test, as it were, being applied on that page, 7579, lines 5 to 6. The judge would not, we think, have felt able to eliminate the real risk that the juror might, as a result, whether consciously or unconsciously, have become prejudiced for or against one or some defendant. So that seems to be the test, is applying a real risk of prejudice, either conscious or unconscious.
Yes, and that's, of course, one of the problems with the approach to the other jurors, is the other jurors may say, oh, I think I can reject this bribery attempt. But of course, they then got something, a very prejudicial piece of information in their minds, very difficult potentially to eliminate that. And of course, that test was being applied before Porter and McGill and before the adjustments, relatively slight adjustments, but the adjustments that were made, the introduction of the fair-minded bystander test. But it still echoes that test because it's applying a real risk approach. So it's, and our submission remains valid. And that, the approach he describes, it's just worth looking at the bottom, as I say, the last 10 lines in particular of 7579, where Lord Bingham essentially focuses on the need for his language, collective integrity and individual integrity. That's obviously a problem if you've got one person who's offering bribes. It's impossible to see how there's either collective or individual integrity. Deals with the issue of potentially isolating the poison, but recognises there's a real problem if you can't isolate it. And of course, here, the poison couldn't be isolated because the judge allowed the juror offering bribes and everyone who knew about those bribes to participate in the decision making, in the verdict. I'm slightly overrun, but that's probably a good point to break for lunch.
Yes. Thank you, Mr. Sully.
Sorry, I assume that's probably a little presumptuous.
It's a convenient moment for the court as well. We'll adjourn and resume at 2 o'clock.
I need to move on, but one thing that I would just emphasise about Putnam is the language that Lord Justice Bingham, as he then was, used towards the end of page 759 in that passage where he talks about collective integrity. And he talks about the high regard in which juries are held, depending on their collective integrity and their individual integrity. And that's important in one sense, because it demonstrates how, in our submission, judges actually, although obviously judges need to avoid discharging unnecessarily because it's a waste of resources, etc. At the same time, judges should not be reluctant if the circumstances arise to discharge the jury, because it's by doing that that the regard of the jury is, in one sense, preserved. It has one other factor, that it has one other result, which in our submission is demonstrated by the facts of this case, and explains why discharging the jury is not that uncommon, we would submit, and that's that discharging the jury in the right circumstances prevents people having to then exercise appeal rights, essentially potentially being held on appeal, in custody rather, until the appeal is heard. It ensures effectively that someone's fair trial rights are vindicated as soon as possible. I'm going to move on fairly quickly because of time, but there are a couple of things I just want to make, a couple of points I want to make about the suggestion, which seems to be at the heart of the prosecution case, essentially, which is that all of this could be dealt with by jury directions. And the first point I want to make is it links back to the question, or the point I think my Lord Reid put to me just before lunch. Jury directions obviously can be, I was about to say but I don't think it won't always be the case, and that's why I changed my language. Jury directions can be important ways of keeping a trial on track. The fundamental problem, though, in this case, there are two fundamental problems that explain why jury directions, even if they had been in stronger terms than the ones in this case, would not have been enough. And that the two fundamental problems are this. Firstly, it goes back to a point I made this morning. One of the jurors had already been willing to offer bribes. He was willing to break the law. Directions assume that the juror will comply with what they're being told. But if a juror is willing to demonstrate that they are willing to break their oath, willing to act unlawfully, directions cannot solve that in our submission. The second problem with a direction is that implicit in Putnam, and what is said in Putnam about the potential for late reporting, for example, demonstrating that a juror had failed to comply with their oath and was going to be unable to avoid being biased. Implicit in Putnam is the need to know how far the poison has spread, to use the language of Putnam, before giving a direction, because directions will only work if the poison hasn't spread too far or hasn't become too deeply embedded in individuals' thought-making process. Here, because of the limited information about what had actually occurred, in our submission, there was no way of knowing whether the directions were sufficient. And that's one of the reasons why questioning the jury can be important. Which would say, and I'll come back to this in reply if necessary, but it's probably clear from our case. In any event, all that was said in this case, of course, was that the jury were reminded of their oath. Smith, I won't take you to it, but it's 7671, House of Lords at para 24, makes it clear that directions need to be apposite, clear, and emphatic. They were not in this case. And there's no reason why the jury couldn't have been expressly addressed effectively about bribes and how they should ignore the bribery attempt, because of course on the evidence given, or the account given by the forewoman, not technically evidence, but on the account given by the forewoman, everyone was aware that there'd been this approach. Everyone was aware that one of their number had been placing a bribe. But as I say, fundamentally in our submission, this was a case, and there have to be those cases where it's just gone too far. The Crown has raised the issue of the proviso. In our submission, the proviso is inappropriate in this context, and we've certainly, neither side has been able to identify, as far as I'm aware, any case where the proviso has been applied in circumstances where an appellate court has reached the conclusion that bribery or similar problems have occurred. The reason for that in our submission is this. Under the Charter, as you've seen, there is a constitutional right to be tried by an independent tribunal. The Jury Act, unsurprisingly, given what is common practice in many countries around the world, provides that in Bonnet Taylor, which is in the authorities at 6289. The normal approach that is often adopted in things and you are potentially denying that. I'm helpfully, it's extraordinary how quick juniors are these days. Seraphin, I'm told, is the court, the judge,
right.
para 49.
Yes.
Turning then to the issue of time of jury, I'm not going to spend very much time on it, partly because obviously in one sense, the jury shouldn't have been retiring at all on our case. We're all concerned about this case because it's quite clear, and the Court of Appeal recognised this essentially, that one of the reasons why the judge was keen to get the jury out, so to speak, is because the trial couldn't continue without that juror. And so you had this situation where there was a potential need to take out against a juror who, and so a quick verdict was being sought. Now, the Jamaican bench book clearly recognises the potential pressures that can be put on a jury, and we would submit that one of the problems, if you have a jury that already has problems with pressure, the problems of pressurizing a jury become even more intense. And that the reason for that simply is that if a jury is going to be potentially influenced by unconscious bias, that risk increases if people are effectively pressure. Go to your prejudices, unfortunately. If you some people tend to go to their prejudice prejudices if they're under pressure. That's the simple point I'm making. And that sending a jury out puts pressure on them, and it particularly puts pressure on them in a situation essentially for the jury to be discharged. They know they're going to be kept together. They're not going to be able to go home until they reach a verdict. That's recognised. The passage 6801, paragraph 5, which recognises what it describes as the 3 p.m. benchmark, but recognises flexibility both ways. And so in complex cases, remember this is apparently one of the longest criminal trials in Jamaican history. In complex cases, it may be necessary to complete the summation earlier than 3 p.m. to avoid pressure. Sorry, 6801, and it's paragraph 5.
8601.
No, 6801.
Oh, I beg your
Sorry,
pardon.
no, that was probably me.
No, no. 801.
Case, you had the added complication that when the jury was at 5:35, were asked if they'd reached a unanimous verdict and said they hadn't. Reference to this is 5176. The prosecutor then pointed out that they'd not been out for 2 hours, which is the point. There's no direction essentially saying unanimous verdict. That's inconsistent with another passage of the bench book that is at 8362.
And can I ask, in Jamaica, if they go out and they haven't returned a verdict by a reasonable time in the evening, is the practice to send the jurors home, or are they sequestered in a hotel?
They cannot be sit, basically.
Yeah, yes, and so are they kept in a hotel under court supervision?
That would be my understanding what we like, but obviously the bench book is premised on the idea that it's ideal that that doesn't happen, really.
Yeah, but even sending, I mean, I know from my own experience, even sending out the jury earlier in the day, that you can still have them out overnight.
Yes, absolutely, obviously, and that's not uncommon. In
fact, sometimes it takes a number of days before they return a verdict.
But does sequestering happen in Jamaica? Because I noticed there's another case where the hearing went on until 1:30 in the morning, where you would have thought they'd all be in a hotel by then.
No, in practice, sorry, I should have been clear. In practice, it doesn't, because there's just no real provision for it. So the jury just stay late.
But there is a rule that they can't be separated once.
The Jury Act is clear on that. They can't be separated.
So deliberations can go on for days and they'll just be kept without being sequestered in a hotel?
In principle, I suspect in reality that doesn't happen because of the natural I mean, we haven't put this in because it didn't seem relevant, but there is old English case law about juries being just reaching verdicts at 3 in the morning.
Yeah.
Yes, well, the leading case on coercion of a jury is one where the judge refused to let them have anything to eat or drink until they returned a verdict.
Have you got the reference to the Jury Act indicating that the jury cannot be?
Yes.
Once they've started deliberation, can't be.
Yes, I'm notes. Sorry.
Well, don't bother now. But if it's not immediately, if somebody could just.
Yeah. No. Sorry. I just. It's section 47 of the Jury Act, which is electronic bundle 6805.
Thank you.
I think actually, just sort of as an aside, it was George Davis. If you remember, the George Davis is innocent. He was an early hours of the morning verdict. If that's sort of historic.
That's not that long ago.
Yeah.
But they can be sent home, as I understand it, before they start to deliberate.
Yes.
So a judge who finishes something up, say at tea time, and could just say to the jury.
Bench book makes express reference to when you finish your summation, because that's really what determines it. So what I suspect happens, my experience of English courts.
Save the last direction about unanimity and electing a foreman until first thing the next morning.
Yeah, exactly, and that's not uncommon even in England, where it's getting late.
Regular.
You have
suggests that the solution is not, if you finish your summing up late, send them home, but not to finish your summing up late.
Well, I think that it's because of the technical issue of when do their deliberations start. But all you need to do is have like one line of your summing up, and that
just save the last sentence of your summing up.
Yeah.
Okay.
47.3 at page 6805 does imply, well, it does say that the judge can give directions as regards accommodation.
Yes, but I understand in practice, and obviously I don't have direct experience, but those who do tell me this, that in practice that's not applied.
Thank you.
Final issue, and as I said, there are obvious issues in relation to the time in this case, particularly given the complexity of the case. In terms of what you should do if you're with me and have concluded that the conviction should be quashed and the proviso shouldn't be applied, we would invite the court not to remit. This has obviously been outstanding. The appellants have all been in custody since the 30th of September 2011. That delay is likely to have had an impact on evidence. There are, as the court will be aware, because of the application for expedition, there are issues with the health of one of the appellants. There are also obviously constitutional issues, but they've been denied. We would submit constitutional issues to a fair trial. If we're wrong about that, though, we would invite you to consider remitting to the Court of Appeal so that the Court of Appeal can consider the issue of retrial. That, I think, concludes all I have to say. I think Mr. Buchanan has some additional submissions.
Yes.
Yes, Mr. Buchanan.
I'd be pleased with the court. Lord and ladies, I just wish to make a point, a couple points, but to start with questions, the clarifications to question Lloyd Jones. And this would have been in relation to in relation to the chamber hearing. Now, in right of the accused to be present at all stages of the proceedings, the concept of the chamber hearing respectfully would be that the courtroom would become the chamber. Yeah. So the gallery would be cleared, and certainly the attorneys, the representatives, and then you would have the accused there.
The bench book says that.
That's correct. But in that situation, because it was a situation within the transcript which reflects that it was actually a conversation between one of the appellants and the son of the jury. She didn't actually see or confronted the appellant. And so she was concerned. So she only carried information, and the inquiry didn't go as far as to find out the truth of that inquiry. And so it led to a discharge. What follows from that is the opportunity would have been lost for the appellants, if questioned, or to say, well, this is not true. And then the judge would have made an informed decision. What follows from that also is that the foreman, she was a part of the questioning. She was then asked if she was allowed to, if she could continue. She says, I'm only worried about the safety of the juror number 11. And she leaves knowing the information, and it's fresh in her mind and remains in her mind. We have no way of knowing but to speculate how much conversations outside of that would have gone to the other jurors. Then, moving back to the next inquiry number 3, it is the same forewoman and more conversations about her role. And so the taint or the poison would have gone back as far as November in a 65-day trial and before juror number 11 left. So a proper inquiry could have found out, especially in a space where we do not know at what point or if any, when it is exactly the responses, or if the other jurors could have said that that wasn't the case at the time, if a proper inquiry and asking each and every juror, not even suggesting that it be done on the oath, but if it was asked what their responses would have been for the judge to make an informed decision. And I say this in the context that in light of the fact that our Constitution, it places even a duty on the judge to, as the custos morum of the Constitution, to protect the rights of the appellants, that it was incumbent on him to ensure that he makes the inquiry so he protects the fair trial right. So that would be in response to your question as it connects. So what flows from that then is when we get to the late retirement, we have a juror who is the fruit of the poisonous tree or the introduction of the poison, no knowledge of how far the poison is. I'm not inviting the court to speculate, but that's all we are left to do respectfully. And what happens in that situation is we don't know if the pressure arises because there was a situation where these jurors were able to say, I would participate in a bribe, allegedly, or not. And so the verdict that comes could never be a true verdict in light of that. So that's the submission as it connects from incident 2 to incident 3. Now, in relation to the proviso, and I think you had knocked some of the wind out of me, say, Lord Reed, because I would have borrowed your words in the judgment to say that you can't proviso unfairness, you can't proviso injustice. It's just not possible. It would have been an absurdity in the law. Now, in relation to Lord Simla, Lady Simla, you asked a question about the balancing of rights, the balancing exercise. I would submit to you that the Jamaican Constitution, in particular the Charter, it came at a time post the Phipps decision. So there was a lot said about King and certainly Phipps, the Phipps judgment. But at that time, it was presumption of constitutionality, and certainly the onus was on the appellants, on the appellant to prove the privacy right violation. Post the judgment in Phipps, our legislators, which our parliament certainly has that ability to represent the people, and they would have thought that as a matter of public interest, the very right, the charter rights, in particular, the communication rights, which is for all, the least among us has that right, was to be protected in such a way that where there is a breach of that right, it's a distinct difference. What difference is that? Lady Simno would have asked, is that the judge now has a duty to carry out the Oakes test or the demonstrably justifiable test, because somebody says, and in response to Lord Reed, but the appellants are not here to complain of that right. But they did at first instance to their counsels collectively. And at that basic complaint about the right follows that the judge is to call upon the prosecutor to say that it is demonstrably justified because there's no issue before this court that there was a breach. The effect of the breach or the balancing exercise can only begin after the prosecutor has met the burden of demonstrably justifiable.
Can I ask Mr. Buchanan, while you're addressing us on the Charter, as I understand it, the Charter is formally, is part of a constitution. It was made part of a constitution by a constitutional amendment in 2011.
That is correct.
Was it preceded by some sort of review or report?
My learned friend actually, Mr. Salty Casey, actually made mention of the review and the report.
Oh,
but
right.
what is significant?
Check my notes. Right.
Right. What is significant that comes from it is that, and we take pride in this, and I'm quoting, I'm paraphrasing our Chief Justice, and it's found, thank you, it's found in the written case at 12 and 13. Yes.
Right, thank you.
Yes, but what we, as I was saying earlier, we take pride to say that this amendment, which is separate from any other Caribbean jurisdiction, was for us, it was made by us, and it was a testimony of our evidence of independence.
Yes.
Where we decided what rights would be protected, and especially the dynamics of the Jamaican society.
Yes.
Is the importance of protecting the least among us.
And was it intended that it be developed, I suppose, was it meant to be what you might call an autochthonous Bill of Rights, if we can call it that would be developed by the Jamaican judiciary in light of the circumstances in Jamaica? Or was it intended to be influenced by comparative human rights jurisprudence, looking at other charters of rights and constitutional guarantees in other countries?
I'm happy that you asked that question, because we did look, and I'm saying we because I take pride in being Jamaican, but we did look at other jurisdictions such as South Africa. Mm-hmm. And if you even the Canadian and the United States, but what you'll see, what a clear indication, and again, my friend is indicating that it's in the written case at 20 and 21.
Yeah.
But what's significant is that what is clear is that there is similar to in the Canadian jurisdiction, that the test, which is the demonstrable justifiable test, is mandatory once there is a breach. And before us now is that there was a breach. Yeah. The learned judge, and I will say this respectfully, this came at a time when the charter was very young. And so the contemplation to give effect to it, as judges do in interpreting the intent of the legislature.
Oh, yes, and I see paragraph 13 draws our attention to what the Chief Justice Sykes has said, that it's autochthonous, which means it's indigenous, homegrown, originating with us rather than imposed from outside.
And what is key, which I will get to, and I agree with you, and I adopt the words of our Chief Justice.
Yep.
Is the fact that after looking at constitutions all over the world, what we decided is what is important to us. So what we have is a section 13.2b, and I know there are many persons, I quote it so much that it becomes an annoyance to many, but 13.2, the protection given to every citizen under 13.2b. It is the last flicker or shimmer of light to what it is to be a human.
Yeah.
And it separates the state clearly from the human being. And it says, listen, all state actors have a duty not to abridge, abrogate, or breach the rights. And when you do that, you must show that it is demonstrably justifiable. So in an answer, yes, thank you. So in an answer to that, ladies and gentlemen, that balancing exercise as to the evidence when it was asked about, especially in relation to what was on JS2, doesn't even begin to come up until after the judge would have made that, carried out that exercise of the demonstrably justifiable test, and he did not do it.
Yeah.
So we have nothing on the record as to any submissions from the state, from the Crown, to say, here, notwithstanding, it is justifiable. There were less restrictive measures, or here's why there is a breach. So we don't have that before us, and that is the one flaw in the judge's acceptance. And evidence of that is he was concerned. He made words to my senior, Mr. Taylor, who is in the room, that if he was not daunted by the change in the charter, because and the significance of it, the response at that level was nothing much changes even after the concession. But we do recognize the importance of it, but to submit to the court that the test wasn't done, and so there's no balancing exercise to which could have happened. And because this is our apex court, the apex court could not respectfully substitute what the judge at first instance ought to have done. And in those circumstances, the answer to question A, where evidence was collated, collected, and secured. So secured would have been the request from the police officer. The collection and collating would have been what flows from JS to the cell site, the text messages, the call positioning, whatever flows from JS2. But all of that would have been no moment. And a key thing before I depart, because I don't want to take up too much time,
well, you don't have a great deal of time left.
I was being cheeky, Lord Reader. I didn't know you would figure me out. But the key thing in relation to that aspect is to understand that as we make heavy weight of JS2, what's incumbent on the judge was that in a demonstrably justifiable test, I would submit respectfully that in the absence of JS1, which was the controlled copy that the police officers did not have access to, and where the much counsel from the lower level, which Tom Tavares, KFC, would have said, listen, this is a man from Ireland who would have come to Jamaica, not given any effect to the right, and he gives testimony. This is Simmons, and he doesn't say whether he knows exactly what's in each and every file, and we have nothing to cross-reference, so they would have failed on that test. The last thing I will say before I take my seat, my lords and my lady, is in relation to the trial, the jury point, is I certainly, and I've read for this case about 4 years, in relation to the jury point, it has never been in the modern common law where a jury who we know for a fact is poisoned, is tainted, was allowed to remain on a jury to bring a verdict simply because the legislation would have prevented him from being discharged, where it is clear on its face that that juror ought to have been removed to protect the fair trial right. And it is in that vein that I will say that there is no cure, no proviso or no thought of a retrial or a second bite of the apple, where the unfair trial right was breached in the manner that it did in the circumstances from incident 2 to incident 3, and then the justification for breaching what we know is common practice in the Jamaican space to ensure that you leave one sentence so that the deliberation takes place on the next day. And that would be my submission, that the conviction should be quashed or ought to be quashed. And I trust your wisdom on that. Thank you.
Thank you, Mr. Buchanan. Well, if we've heard all counsel on behalf of the appellants, then I'll turn to Mr. Knox. Now, Mr. Knox, I don't want to knock you off your stride before you've got started, but it would be helpful to us if you were able to address us first on the jury issues, and then we may consider whether we need to hear you on the JS2 issue.
My lord, yes. Doesn't knock me off my stride too far. But I have to read my handwriting as opposed to the typed. Can I go first with the first of the jury questions that remain? And go first of all to E4072, 4072. Which is in bundle 5A, if anyone's working from a hard copy. I would just like to show you what happened, because there is more to it than you were shown by my learned friend. The incident begins at 4072, 6th of February 2014, so it's about a month before the end of the trial. You'll see at the top of the page, court resumes at 2:25 p.m.
Yeah.
But they're all in chambers with the judges, with the attorneys.
Yep.
And Marlene Catwell is the juror. And the first part I would like to take, just say line 24, the witness, that's Catwell, one Friday. So it doesn't identify which Friday. When we weren't at court, I went to visit him, my son. We were supposed to go to the lobby, but him never come out in time. But just as him come out to me, Andrew St. John's came in that way. He saw me, he was a bit panicked, and I look at his face, and he was a bit panicked. It's not quite clear who he is, but perhaps he's talking about her son. And then she continues over the page.
Her son or St. John?
No, her own son.
But she says her own son didn't come out.
Okay, oh, he saw me, sorry. In other words, St. John saw me.
Yes,
He was
I think so.
I look at his face. Forgive me, my lady, yes. And then she goes on to say, shortly afterwards, when he came out, when he came out of the vehicle, my son came in and him said inaudible. I was a bit angry with my son. I was a bit angry because he knew that I was coming and I didn't want to meet up with them. So I think his delay make St. John's would have seen me. So I was angry at him. I think I must be her son now. You know me and I come back because him see me. I never related anything. But she then goes on to talk about her conversation with her son. Near the end of the page, me tell him me and a boy in the jail fight. Me go at the medical center and him say to me. So there's been some sort of fight. And then over the page, 4074, she says, no, Kartel saw him and say him see him mother a juror, and say St. John's tell him, but him not tell the other rest of man. So she seems to have seen, or rather Cartel appears to have been involved as well at some point. It's not always easy to understand quite what is going on. But then if one can drop down to the end of the page.
I think we can probably take it the judge understood what was going on.
The judge, I'm not sure he necessarily did. But towards the end of the page, 4074, they who? She says, the prisoners at the bar are there, and my son is there, and they know that I am a juror. If anything should go down, probably, I don't know, if anything go down, I would hate to know that me as the one who have to bury you. And he was saying, he said, Cartel said to him, he was saying, if. So her concern is being on the jury, and then if the jury convicts these defendants, then she's going to be in trouble. Or her son might be in trouble, rather. Yeah. It's not that she personally is going to be attacked, but she's concerned about staying on the jury, because if she does and the jury convicts, then there might be trouble for her son. That's her concern. Then you see Mr. Finson, that's Mr. Palmer's counsel. She don't even have to say any more. Juror Cartel said to him, if he. And then the judge says, okay, what I want to know, though, how you feel. You can bother with this, you can bother with the burden and all of this burial thing you talk about. The witness, Your Honour, the only thing I'm concerned about is my son's safety. They are there, he is there, they know him. Andrew St. John's is on the said block. All right, that's a lot. Please just step down for us, please. It's too much for her. Having heard what she said, I have changed my opinion. Yes, it's too much. So obviously at first he was thinking, this is storm in a teacup, but now he's thinking rather differently. And then the prosecutor, Mr. Taylor, does seem that concerns with her son. And if the authority can find a way to move her son from Horizon, my lord, so she could have peace of mind to continue on the jury, the judge says, no, her son is now in the custody of the state. And then, yes, all right, the view is, Mr. Taylor, as prosecuting counsel, I wasn't trying to be brief and brush your comment aside, but from the performance that I saw her, it's clear to me for a parent to be placed in that situation that the body that she's sitting on may make a decision that may affect the safety of her son adversely. As a parent, it is an act that you don't want to place her in. In the circumstances, I don't think it's something she can properly deal with. You saw her performance just now. And then he goes on to say, therefore, I think I had better discharge her. And then towards 4077, towards the end of the page, Mr. Rogers, I think he's Mr. St. John's counsel, but I stand to be corrected. Another issue. For the record, I would hope that what has happened was not discussed in the jury room. And as a consequence of that, it might have been left with the rest of the jurors. I know it's a painful aspect at this point, but a real concern. May I inquire through the registrar as to any particular person in respect of the jury who would be seized of this information? Registrar, when the information came, sir, two persons spoke to me. That lady and the foreman, that forewoman. I inquired if anybody else is aware of the situation, and she said no. Just the two of them. So that would presumably be the forewoman and the juror.
Yeah. If you're going to read on, I don't think we need to read aloud the foreman's name.
No. My lord, if you could just read on to the end of to 4080, to the end of 4080, you will see what the upshot was. and what takes place. So, my lords, my lady, what you get out of this is no one else knows except the forewoman and Catwell. It's not gone to the jury. And my lords, my lady, there's no reason at all to doubt that, because even the forewoman, I think, says she only found out on this very day. And then the judge finishes at 4081 saying, I'll make an announcement. But she has a personal difficulty, and I'll dismiss her. In my submission, there's nothing wrong with any of this. This is a perfectly sensible way of dealing with the matter. The judge has assured himself that no one else knows that there has been some incident. And I might add, the only, quote, incident is that she is concerned that her son is in the same, appears to be in the same prison as these accused. That's her concern. There isn't any concern, certainly on the face of the record, that her son has actually been threatened by any of the accused already. So there's no basis for saying that she would have, so to speak, spoken to other members of the jury and said that, or indeed to the forewoman. So I submit there's nothing here which required the judge to go any further than he did. My learned, I think, can I just ask you also to note that this incident began, I think, going back at 2:25 p.m. That's 4072. That's when the Chambers meeting begins. When you get to 4082, you can see the time at which the Chambers meeting finishes at 2:50 p.m. And then the court resumes at 3:16 p.m. Now, I mention that because it is suggested that the appellants themselves, there was plenty of time for the appellants to be told, to the extent it was relevant, what had happened by their counsel. The gap between 2:50 p.m. and 3:16 p.m. The second point is, anyway, their counsel just simply didn't object to the course taken by the judge of holding this in private, nor did they object to the course, the more general course the judge took of removing the juror. That's a point made by the Court of Appeal, and in my submission, that's a good point. And there's no reason to interfere with the Court of Appeal's judgment on this issue, which is referred to in our respective cases. Can I just also draw your attention now to the case of Bonnet, where a not entirely dissimilar thing appears to have happened, and it's in the electronic bundle at page 6287. And that's where the case is. Forgive me, my lords, I think I picked up the wrong bundle. It's 6287. The relevant paragraph, if I can ask you to look at it, 6289, paragraph 21. And if I can just ask you to read that to yourselves.
Just paragraph 22.
So paragraph 21 and paragraph 22, and then 23. It's 21 to 23, in particular 22 to 23. Where a similar sort of argument was run in slightly similar circumstances. 23 in particular. And the reason I draw attention to that is there are two things. First of all, it's up to the judge. When you get these unusual spin balls that come your way, it's up to the judge in the immediate circumstances to work out what is the best way of dealing with it. And I do submit hindsight and perfection are rather dangerous guides when that's the question. And that's the Orgles case. The second thing is the Lord Hope emphasises, well, in that case, the appellant had 3 previous convictions, and the idea was that the juror, knowing the appellant, might then have gone and told all the other members of the jury, which Lord Hope says, but there was simply no evidence of that. So we're not going to interfere on that ground. And I submit, well, it's not identical, but it's a similar type. So I submit for that reason too. There's no reason to interfere with the Court of Appeal's view of that jury incident. If I can go now to the third point, can I just mention this? The judge, just basic facts, the judge persistently gave jurors very strong warnings right at the beginning of the case, and we set them out in our the main ones. Right at the beginning of the case, he emphasizes to the jurors in terms that they are the judges. It's a phrase he keeps on using. You are the judges, and you must decide in accordance with your oath. And I think if I can just go to the key bundle of documents, and so we set it out, the relevant bits in our written case. At page 6236. Yep. I'll give the references, but you can see paragraph 66, and then I'm ashamed to say 65, follows after 66. Those are the things he says right at the beginning. And 67. Now, so very clear direction right at the beginning. Decide in accordance with your oath. Don't speak to anyone whatsoever. And that's, you see, in the two references I give there. And then in paragraph 67, we give various other references. Every time he sends the jury out, he reminds form, don't go and mess everything up now, because it'll be fatal to this case if you talk to people. This is the drift, and I have millions more references, which I don't have to hand, but all the time he's saying to the jury, this is a very serious thing. You mustn't speak to anyone. You must remember your oath. And my lords, I say this is important, and my lords, my lady, I say this is important because after 56 days, the jury would have been well aware of the seriousness of their task and that they must not talk to anyone and they must decide in accordance with the evidence.
But that's talking to somebody outside their number. What we're concerned with here is somebody within the...
I will come to what you might call the naughty juror in a moment, but I mean, obviously, it might be said he doesn't seem to have taken very much notice of it. I agree. I will deal with that. There is that point. But well, I'm talking for the moment about I'm going to address the points of law, obviously. But as a matter of fact, the jury had well impressed, and certainly the 10, if I can put it that way, the 10 had well impressed in their minds the importance of deciding in accordance with the evidence. Of that, there can be no doubt. The trial, they are obviously very well aware of the enormous publicity this case is creating. They know they are doing a very serious job. It's not just a 1, 2, 3 day job, small case. This is the big case in Jamaica. It's on the news every night. Crowds outside the courtroom are separate from the public. And that, in my submission, is an important point when bearing in mind whether the judge was entitled to trust the jury. I'll deal with about miscreant jurors. And they have become apart, of course, from the miscreant juror. There's no reason to doubt that the 10 have acted properly. My lords, my lady, the next point I want to emphasize, and I'll come to, if I may, the transcript, but the bribe was offered by the miscreant juror on behalf of, or rather in the interest of, all 5 defendants, including Shane Williams. Now, you can see why I emphasize that, because the jury obviously did not convict Shane Williams. Well, the 10 didn't. He was acquitted. And I'm going to come in a moment to the transcript, if I may. But while I'm on that point, the Shane Williams point, Chow gave evidence of a fight or the attack in which the 4 men, apart from Shane Williams, were involved. In other words, Shane Williams was not himself implicated by Chow in the actual killing. What he was implicated in was that it was said Chow gave evidence that Shane Williams, who he called Terence, was one of the men in the video talking about a killing. And that was the basis on which the case went to the jury. So there was evidence, the judge did allow evidence to go to the jury in relation to Shane Williams, but it wasn't what you might call the same evidence Chow gave against the other 4 men. If I can just give you the reference for Shane Williams's involvement, or rather Chow's evidence of Shane Williams' involvement, it's at E4011. And so Shane Williams is one of the people identified in the video, which was said to be incriminating. That was the case against him. But I do submit it is important that that is an indication the jury were not just saying to themselves, I see a bribe has been offered on behalf of all of them, so they must all be guilty. The jury has distinguished between them.
Are you going to take us to the references to the 5, to the bribe being offered on behalf of all 5?
Oh, yes. Yes. Because I would like to go to, it's not a very long transcript. I would quite like to go to the transcript to see what actually happened in front of the judge. I'd like, if I may, to go to the facts first, and then I will deal with the issues of law which arise as a result of them. The transcript is at 5.1, begins, the relevant part, I think, is at 5.167. I should say actually 5164 is where the Chambers meeting begins. 2:20 p.m. on the last day of the trial, or rather, last day of the summing up. 2:20 p.m. court resumes, and the judge then reports that he's heard that an offer, a member of the jury has been offering a $500,000 bribe to do a particular thing. You see that about a third, halfway down. My lord, just for information, the exchange rate at that point was in pounds. $180 Jamaican dollars to £1. So we're talking here about, I think, something in the region of £2,700. That's the total number.
So I'm on the wrong page. Which page are you on?
5164. Forgive me, my lord. I did say 5167, then I went back to 5164.
Well, I'm now back. Thank you.
So that's the size of the bribe, if I can put it that way. I'm not saying that makes it any better, but obviously not. But on the other hand, it's not such a gigantic sum as to lead to the conclusion something that, well, can only be an incredibly rich person who's offering it. So the judge says, well, I've heard about this bribe apparently, and he explains how he's come to hear it, and then at 5167 or 5166, you'll see that the DPP has been called in about a third of the way down the page. Now, she didn't present the case for the prosecution, but I'm told by her, she's in court at the moment, Ms. Paola Llewellyn, that when this incident arose, the judge called for her if she was available to come along, as did indeed the deputy DPP. And so she turned up because obviously this was a difficult incident to know what to deal with. So you see there, 5166, she's come along. And then you'll see what she suggests at the foot of the page, 5166. Judge, it's dependent on what your lordship decides. Clearly that's the issue. We'll have to go to another domain. That's between her as the complainant, a particular person. If there's to be credibility in the matter, that's not for you. It's a very serious matter. So she's not encouraging the judge, so to speak, to make any further investigations into this. I submit quite rightly. Judge, if that report is credible, and having heard the thing, one decision will have to be made in respect of that man today. He's going to make up his mind now. DPP says yes, and then the judge says this is all very painful, but I'm going to have to arrange for Madam Foreman to come into the into chambers. You see that about 2/3 of the way down the page. And then the Madam Foreman.
Do we assume that during that period of time, who else has been? Is there any indication who else is with Judge and the DPP?
I think all counsel, I should say, as I understand it, all counsel are present, but not the appellants themselves. I don't think there's any issue on that.
Right. Thank you. Doesn't actually tell us, does it?
You're right, my lord, but I have a feeling, I don't think it's in contention.
Thank you.
And before he says that he's going to call Madam Foreman, he says that he's going to summon that juror, and he's had instructions to the police.
Yes. In fact, he never does.
Yes.
But he does get the Madam Foreman along. And so she turns up. I'm now at 5167 at 2:43 p.m. Judge, you can see what the judge says, 5167, line 19. And if you can, maybe simpler, my lords, my lady, if you read on to 5173, rather than me picking up bits here and there, because there may be other things which I miss out, which you might want to read.
To which page?
5173.
Thank you.
And then I'll make some comments on it. I would say, if you're ready, if I can just draw particular attention to the following points. First, at 5168, it was made with me today, so she finds out today. However, the contact has been made over a period of time with other jurors, and they confessed it to me. However, I cautioned them and told them that we are going solely on the evidence. I told them not to be swayed, that's the word, not to be swayed with what is being said, and they cannot be intimidated by what's been said either. So they're okay. And then she goes on to say how the bribing got in touch with her and seemed to be frightened of her at first, or frightened to do so at first. The second point is at 5170, at the top of the page, he called me out. That's bribing juror. We were in the room. He said he needed to talk to me in the jury room. I asked him what he wanted to talk to me about. He said to me that he knows that I'm influential and people listen to me. I said it's not about listening to me. It's based on whether I pointed them to the facts of what we hear, not to be influenced by what is outside. He said to me, well, he needs me to do him a favor. And then dropping down, I asked him what was that about. He said that we should go to lunch. I said, no, I can't leave because I have things to do and I have somebody coming to me. Basically, he said, I should convince everybody to release, and then in answer to my Lady Simmons' point, the men at the bar, not at the bar. And then over the page, 5171, judge asked of the forewoman, you knew him before you came on the panel? No, I met him here. But when we met, that's when my suspicion of him grew. We started watching and observing his actions from there, because initially he was mad. They chose me as the foreman. He went to everyone and tried to ask them to make him the foreman instead. And basically goes on to say, it's a duty. We don't, being the foreman doesn't mean I'm going to have tea in the judge's chambers, eat crackers and go for lunch. It's a duty. So that's what she's saying. So what she's saying essentially is he seems to have gotten to the head that he wants to be, as well, the big chief. He's disgruntled about this, and she just took no notice. But importantly, towards the end of 5171, but over time, he recognized that, okay, fine, before he started going to these persons and telling them that, listen, this is what we need to do. I would say you are listening to the evidence. He said, no, we just need to let go the men again, them. So when we speak today, he said to me, that's what we need to do. And he says she says the conversation went on for 5 minutes, and she repeats the £500,000 figure. Then towards the end of 5172, he says, as Mr. Southey rightly pointed out, Madam Foreman, 11 of us, he spoke to 11 of us. So that would probably suggest, therefore, the discharged juror. He spoke to 9 persons first. The thing is, nobody's listening to him. Because nobody's listening to him, he wants me to speak to them. I do emphasize that. So I'm not listening to him either. That's the reason why I got him on tape. But the trouble was, it wasn't particularly clear, so it never got played. And then you'll see Madam Foreman leaves 52 p.m. Now, I emphasize that because she leaves in advance, and the summing up doesn't resume, I think I'm right in saying, until about 3:20. So there's plenty of time for her to inform, because she's bound to inform the jurors of what has happened, that she's been to see the judge in chambers. And you'll see 5173, the DPP says to the judge, I wonder if you can allow each team to discuss for 5 minutes. I will wish to speak, and I'm sure my learned friends will wish to speak, perhaps 5 minutes. So again, the reason I emphasize this is there was time for the appellants to speak to, or rather the appellants' counsel, to speak to the appellants themselves. then the DPP towards the foot of 5173 recommends to the judge just warn them again about their oath, just their oath. That is what she is suggesting. And then over the page, Mr. Finson, Tavares Finson, you'll see 5174, the DPP at the top, repeats, as far as the prosecution is concerned, we're prepared for the matter to proceed. Just remind them of their oath. And then Mr. Palmer's counsel, we're of the view, don't see how you can proceed in these circumstances where you've got one person who is making an allegation that someone's going around offering the jurors money. She obviously has some tape, her role. So he seems to be objecting, not on the basis that, so to speak, there's a corrupt juror who is on their side, but rather he's rather concerned about what the forewoman is saying. But in any event, Ms. Llewellyn then says, the DPP says, in fact, it's the prosecution who is most at disadvantage by carrying on. And in my submission, that's obviously right in principle. There's one person who obviously wants to let these people off. There is a risk that he is going to be persuading others, or has persuaded others. And then you'll see at the end, at 5175, the matter ends at 3:07 p.m. And what happened immediately after that is when the summing up resumes, the first thing the judge does, I think I'm right in saying, is remind the jury, if I can just dig up my reference, I hope this is right, 5149 at 3:22 p.m.
Just remind me, Mr. Rogers was representing who?
I think it's St. John.
Right, so you've got Mr. Finson not exactly agreeing with the
Finson's for Palmer.
Yes, I see. But you've got both Mr. Finson and then Mr. Rogers raising, on the face of it, objections.
Concerns, yeah. I would have to accept. They're saying they're not very happy about this. And I think one of them says, I'm concerned about the overcompensation point. And maybe Mr. Rogers says there's a risk of overcompensation. That is to say, the jurors will swing too far in favour of the prosecution because of the knowledge of the bribery attempt. Can I just mention one point before I go to what the judge does? I should have made it before. It's not clear whether, and there was no investigation, whether or not the bribe was coming from the appellants themselves. And that's why I mentioned the figure of £2,700 equivalent. It may just be this particular person was, don't forget, we're talking about very famous people. He's a particular aficionado, we don't know, of Mr. Palmer's and Mr. Campbell's work. But in my submission, what the judge has done, subject of course to points of law, is in my submission, again, very difficult circumstances, but perfectly sensible. He's called in the relevant parties, and on the face of it, the party most affected by the problem, the prosecution, is saying, I'm prepared to carry on. And the reason, of course, for that is that this is day 56. In practice, it will be, or may well be, very difficult to get a retrial of this matter. Another 56 days, you're going to have to get Mr. Chow to come along again. I would hope that you could take the judicial notice of the sheer difficulties, certainly in relation to some of these witnesses coming along again and arranging things. So on the face of it, it's the prosecution who's saying, I'm prepared to take this risk. And the first thing that then happens, going back to page 5149, is the judge reminding the jury at lines 3 to 13 of their duty.
He doesn't say there that they shouldn't hold anything against these appellants.
No, he doesn't. My lady, I would submit it's obviously implicit. I mean, the context here is that the forewoman has been called over to see the judge to talk about the bribery. And she's been told to go back and tell the jurors to deal with the matter in accordance with their oath. And they, of course, will know about these allegations of bribery, because it's said that the bribery has been offered to all of them.
So he can delegate his duty.
Well, my lady, friends like that. But no, I'm not saying he can delegate his duty, but it's quite clear that he's taken a favourable impression of the forewoman, and it's quite a sensible way. He's not delegating, but he's saying to the forewoman, you tell them, as you have been already, you decide in accordance with your oath, and then he reminds them of exactly the same thing when you get to 5149. I agree he doesn't mention, and my lords, one can see why. He doesn't specifically mention, I gather someone has been bribing you. He's in a difficult position, whichever way he goes. And I submit it's a perfectly fair thing to say, I'm reminding you of your oath. It's an oath to decide in accordance with the evidence. And the jurors would have known that was their obligation.
Sorry, which page were you on when you're saying that he immediately tells the jury?
5149. The summing up resumes at 3:22 p.m. 5149. So the first thing he does is tell the jurors after the break, which everyone knows what it's going to be about. First thing he says, decide in accordance with your oath. In my submission, economy sometimes, just making the main point, is the best course. And this, in my submission, is a perfectly reasonable course for the judge to adopt, because everyone knows what he means by this. Can I just also emphasize that subsequently, at 5157, the judge repeats the direction he had already given, but importantly, he repeats at 5157, decide the case against each of these defendants separately. That's 5157, lines 10 to 18. And he then goes on at 5159. He gives the standard directions about reasonable doubt. At 5159, at the invitation, I think I'm right in saying, of the deputy DPP, who was back in the seat, so to speak, he gives good character directions at 5159. And I think those good character directions applied to all the defendants, bar one. It may have been Mr. Jones, I'm not quite sure. Now, I mentioned the point about Shane Williams being acquitted. That, in my submission, is not an insignificant point. There are ECHR cases, which I don't have immediately to hand, but I'm sure I can find them in a minute, where problems have arisen, where the jurors have reported to the judge that one of their number is making racist comments. And there was one case, I will come to in a moment, where there were two defendants, and they were both Asian. And the report gets back to the judge. I'm very worried about this. This chap keeps on making racist comments to that effect. But the jury convict one, but acquit the other. The matter goes, of course, to appeal, who say, well, there's no doubt there was reason to suppose bias, but on the other hand, the judge gave directions to follow your oath. And the matter went to the ECHR, who took the same point. And they said, well, the judge did what was necessary, he reminded them of their oath, and you can take into account the fact that the jury don't seem they do seem to be able to distinguish between the guilty and the innocent. My lords, my lady, if I can perhaps just have a moment, or if I can remind you of what that was in a moment, but I submit that is important. One cannot simply ignore the fact the jury, on the face of it, have performed their duty. They've put this evidence, they've looked at the evidence, they've acquitted one person on whose behalf or in whose interest it was said this bribe was being offered. I think the name of the case is Gregory, but I don't have it. I don't have the reference to hand. So that's what I want to say about the facts. Then I come to the issues, if I may. I say there are two issues. The first is, was the judge obliged to discharge the jury? Did he have to? Did he have no real choice as a matter of law? The second issue is, if he was not obliged to discharge the jury, was the procedure he followed sufficient to ensure that all the defendants received a fair trial? Now, the first issue in my submission raises in turn two questions. The first is this: was the judge obliged to discharge the jury on the basis that there was good reason to suppose that one of them was biased in favour of the defendants, or indeed all the defendants, regardless of the prosecution's willingness to continue? In other words, just as a matter of law, was the position such that, look, you haven't got 11 impartial jurors here, we know you've got one bent one, he's bent in favour of the defence, but you have to discharge? And that's the first question as a matter of law. Notwithstanding the prosecution's waiver, if I can put it that way, of the point. That's question number one. The question number two is, was the judge obliged to discharge the jury on the basis that realistically the other 10 jurors, the non-bribing juror, the other 10 jurors would consciously or unconsciously be prejudiced by their knowledge of the offers of bribes. Prejudice against all the defendants, regardless of the directions that he had given, or indeed could give, to tell them to abide by their oath. That, in my submission, is a separate question.
The lawyers put in Putnam is a real risk that they might have become consciously or unconsciously prejudiced.
Real risk they might have become. That's why, forgive me, my lord, that was, I was trying to go by the Putnam test, consciously or unconsciously. Is that something which is going to be in the back of their minds, come what may? Now, on the first question, namely, you've got one rotten apple here, so that's it. We say that can't be right. And we have in our written case drawn attention to the case of Brown, which is in the electronic bundle at 6329, paragraph 31, where a not identical thing happened, but the problem arose: what is a judge to do? Or rather, the point was made that the defendants cannot derail trials just by making offers of bribes to juries and so forth. It's not on all fours, but I submit it is important all the same. So it's 6329. And it's paragraph 31. We fully understand any judge's reluctance to discharge a jury in circumstances to which a defendant bore material responsibility, although there are no doubt gradations of responsibility, starting with deliberate misconduct by a defendant aimed at achieving a discharge in circumstances where a trial is going badly, or at achieving a favourable verdict and ranging downwards in seriousness from those situations. Counsel for the appellant thus rightly, in our view, accepted before us that it cannot be open to a defendant to obtain the discharge of a jury by deliberately creating some ground of aggravation or discord between him and the jury, whether inside or outside court. But in order for a judge to rely on the appellant's responsibility for events occurring as a ground for not discharging a jury, the circumstances giving rise to such responsibility must, it seems to us, either be agreed or ascertained by the judge to exist. They cannot be assumed simply as a prima facie case. Now, that's not on all fours, but I submit the basic point is this. It's not open to either a defendant himself or indeed a juror acting, if you like, without instructions from the defendant, but nonetheless in the defendant's interest to derail a trial. And I submit that's an important point, and I submit it also goes to the whole jury system. And it will bring the jury system into disrepute in a case such as this. If the position is really this, there are 10 innocent jurors who have performed their duty, assume for the moment, who have performed their duty without any shred of bias. It would bring the system into disrepute if the verdict is nonetheless to be set aside because of the one bad juror who was not obeying his duty. I submit that would be, one can understand what you might call the purest version of that. One can understand, of course, the notion that a jury has collective responsibility. But in my submission, that would be would strike, I submit, what you might call the man in the street, the sensible man in the street, as a remarkable result.
But the normal scenario would be that, of course, you get rid of that juror.
I agree. The difficulty here...
I mean, you wouldn't say, well, you can carry on with that juror.
But I think, my lords, I'm bound to accept that we don't know, of course. But obviously what concerned the judge is I don't think I took you specifically to it, but he does at one point say, what am I going to do? Either I let the juror out, in which case the case can't continue, or it carries on. I accept what your lordship says, but my lord, again...
What I'm saying is the quote from paragraph 31 leads us to the obvious result that, of course, a juror who's refusing to obey directions has to go.
He has to go. Well,
that doesn't then follow that, oh, you can leave him on.
No. Subject to one point, what I call the waiver point. And the prosecution here, it is, as they pointed out, they're the losers in this. And they are prepared.
How can you be sure? You just don't know. You don't know.
Well, my lady, funny enough, we do know in one sense because it was a 10-1 verdict, and we know from evidence acquired afterwards that you know who was the one. I don't think there's any doubt about that. And that was a matter of witness evidence obtained by, funny enough, the defence afterwards.
Yes, but if there's a, well, I think the point that her ladyship is making is that one doesn't know how people may react to an attempt to bribe them. If a jurors thought that an attempt was being made to bribe them on behalf of the defendants, then that might have, who knows, it could have inclined them to dig their heels in and prejudice them against the defendant.
My lord, I agree. That of course, is the second question. I'm just on the first question for the moment. Can I, namely, there was just a rotten juror. Does that of itself mean the verdict cannot stand? And can I give you an example where I submit it is not of itself a sufficient reason? Supposing what happens is this. A jury comes in with, let's say, a 10-1 verdict. The one has been bribed, but the one has not revealed that to anyone else. It all comes out after the trial. Can the defendant come along after and say, oh, dear, 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 there was a rotten juror on that, he didn't tell anyone about it, but nonetheless the verdict must be set aside because there was just one, as it were, there was one person who wasn't performing his duty, qua juror. My submission would be that would receive short shrift from the appellate court. It would say, well, the rotten juror didn't speak to anyone, he didn't obey his duty, he did come in with a not guilty verdict because he'd been bribed, but on the other hand, that made no difference whatsoever to the 10 who did come in with a guilty verdict. We know it didn't, because he didn't even mention it. Now, in those circumstances, I submit the verdict would stand. And I simply give that as an example as to why what you might call the pure point, there have to be 11 good jurors, even when there's a 10-1 verdict and the 10 are good. There have to be 11, and the whole thing falls to pieces. Cannot be right. And I submit that, if that, in the example I've given, that would give rise to very considerable public concern.
But the trouble is, we don't know.
I don't have that.
We're not supposed to know.
I know we're not.
Who's saying what in the jury room? So you can never. So the hypothetical you're given can never arise in reality.
Well, my lord, I hesitate to disagree, but I would submit it could arise, and indeed, in this case, we do know precisely what happened. Yeah. I mean, supposing Livingston came for whatever reason, supposing he had not mentioned any of this to the jurors, but afterwards it came out that he had actually received bribes and was convicted. But let's just say, or he had received bribes from one of the defendants. So it's not on all fours, but I'm simply at the moment on the point, do there have to be 11 good jurors, full stop? And if there's one bad juror, the whole thing falls away. I submit that's not right. The other question is the different question entirely. Namely, what about the juror, the 10 good jurors, saying to themselves, huh, well, you know, obviously, they're all bent, these people, and so I'm going to hold. It's a sort of little bit of prejudicial information which they're holding against the 4 appellants. That's the question. Now, my respectful submission on that is, as well, the second part of the question is this. The question is, was the judge bound to assume, in all the circumstances, that whatever directions he had given, or could give, was he bound to assume that the taint, if I can put it that way, of the bribing juror was never going to leave the minds of the 10 good jurors, such that, maybe even unconsciously, they would hold this against the accused?
But isn't that the wrong way round? Doesn't he have to be sure that there isn't that risk, rather than the way you put it?
Well,
he has to be sure that there won't be, that justice will be done,
yes,
rather than the other way around.
My lady,
I'm trying to.
Yes, I'm bound to accept that. I maybe have too many double negatives in what I was saying. I accept he has to satisfy himself that he is in a position, given what he's already said and will say, to ensure that there will be a fair trial for the other appellants. That's the question. And in my submission, it's a question of fact to an extent, but on the facts, I submit he was entitled to come to the conclusion that the 10 jurors, with proper directions, would not take into account the fact that one of them had been offering bribes. And that, in my submission, was obviously a matter for the trial judge himself to assess, and that's how he assessed it. And my lords, my lady, I also rely on the fact that the Court of Appeal upheld the judge's judgment on this point. So what you would be effectively doing is saying to as with the local courts, they were wrong to hold that justice, there could be a fair trial, notwithstanding.
But the Court of Appeal appears to have been comforted by the fact that there was nothing to be gained by questioning or looking into the matter any further, at best a denial of bribery, and a great deal that would have been lost, the possibility of having to discharge the whole jury. Was that the right approach?
Well, my lady, I think one has to bear in mind what was being put to the Court of Appeal. I think from recollection, what was being said to the Court of Appeal, and there's not so much being said now, is that the judge should have carried out an inquiry. He should have made more inquiries. My answer to that is that if the judge was satisfied that a direction would put the matter right, then he was entitled to take that course. I agree. I agree. The question is, could he rationally be satisfied? You might say if he couldn't rationally be satisfied, well, that's that. But in my submission, he could be, for the reasons I've already, in a sense, gone through right at the beginning. He has reminded the jury of the seriousness of their role and the importance of deciding in accordance with the evidence. He's told them again and again, you are the judges. You are not to speak to anyone. They are well aware of their special position. And I submit it's quite often the case that prejudicial information comes out in the course of the trial, which gets in front of the jury. And as long as a judge's direction, I'll come on to the direction in a moment, as long as the judge's direction is sufficient to ensure that the jury will decide in accordance with the evidence and not in accordance with the unfair prejudicial material, then he's entitled to take that course. And my lords, my lady, obviously one can well understand, of course, the concern in this case. Of course, that it might be said, well, who could forget? But my lady, my lords, I submit it's not that difficult. Jurors have to be trusted to act in accordance with their oath. I want to take you to a case about that. It's a fundamental, it's a cardinal principle that jurors do act in accordance with their oath. And they act only in accordance with the evidence. And if I may, can I take you to, again, take you back to the case of Bonnet, where Lord Hope makes this point, and he refers to other cases of higher authority, which say the cardinal principle of jury trial is that jurors act in accordance with their oath. They're not nincompoops.
Can I just ask you, in the context of your submissions, do you see any role for the Porter and McGill test?
It's fair to say that where I'm putting it is that the question is whether there was a fair trial or not. And in my submission, if one could be satisfied that there was a fair trial, that is that. I mean, in one sense, I accept that what I'm saying is that if the court is satisfied there was no risk of well, in one sense, Porter and McGill is to do with a real risk of possibility that the tribunal is biased. But it's not the appearance so much, but there is a risk of possible bias. And to that extent, I accept Porter and McGill is right, because in my submission, what the judge did was to remove any risk of possible bias. It's not quite the same way as the Putnam test, but it comes to much the same. But appearance of bias per se, if it is not the relevant test, the question is, was there a real risk of possibility of bias?
And you say he removed that by the direction he gave at 3:22.
And also by what he'd been telling them before. It's the whole thing has to be looked at. It's often said in the cases that the judge is entitled to look at, the judge in making these sorts of decisions will bear in mind his view of the jury, so far as he can tell, over the course of the hearing. And in my submission, he was entitled to take into account also what the forewoman had said to him. And I do submit, if one asks, and looking at everything, if one looks at A, the verdict, B, the letting off of Shane Williams, and C, the evidence, which I'll come to later if I may, which is simply overwhelming. One asks, what unconscious bias, so to speak, added to all the evidence which was there anyway? How could it have done? And that is the point about the strength of the case. One can see where the evidence is equivocal and so forth. One might say, well, that's rather harder to tell. But if it's 2 and 2 equals 4, well, there is in my submission a basis for saying the risk of the possibility of bias it has been removed, was not likely to have affected the jury's verdict, or won't have affected the jury's verdict. Can I just take you to the Bonnet and Taylor case? Because it is important at this point. To what extent can you trust the jury quite properly and in accordance with their oath? And we looked at one passage already. It's at 6291. Paragraph, I think I'm right in saying, 6290, one can begin at, paragraph 24. There was, however, another course that the judge could have taken, and did take in this case. That's, let's say, not making further inquiries about the juror. At the outset of his summing up, he gave the usual direction to the jury. It was for them to decide what evidence to accept and what to reject. He then gave this direction: decide this case on the evidence. Do not be influenced by anything you might have been told by anyone, whether by some fellow member of the jury that sat or are sitting with you about some prior knowledge or feeling or view. That is because that's not the evidence. I hope that I'm making myself absolutely clear that it's the evidence and only the evidence in this case that you have heard that you're entitled to act upon and determine. Having looked at the evidence, examined it, weighed it, determined what facts are, and ultimately what your verdict is after applying the law. And I will give you to the facts that you find proved. Now, I agree that's a stronger warning, but nonetheless, it's to the same effect. Then, the important passage in paragraph 25, the assumption must be that the jury understood and followed the direction that they were given. See, a judgment of my own, as it were. In the Supreme Court of Canada, in Corbett, Chief Justice Dixon said that the experience of trial judges is that juries perform their duty according to the law. In the High Court of Australia, in Blenheim, Mason CJ and Tuijay said that the law proceeds on the footing that the jury, acting in accordance with the instructions given to them by the trial judge, will render a true verdict in accordance with the evidence. To conclude otherwise would be to underrate the integrity of the system of trial by jury and the effect on the jury of the instructions by the trial judge. In the Irish High Court case of Z, Hamilton P. expressed confidence in juries to follow the directions given to them by the trial judge. The direction which the judge gave in this case was clear, understandable, to the point. The board is satisfied that it is sufficient to deal with any risk that the juror who was excused might have said something that the jury ought not to have been told. Now, of course, my lord, everything turns, in one sense, on the facts of a particular case, but I do submit it as a fundamental principle that you trust the jury to act in accordance with their oath. And it is implicit both in the judge's decision to leave this matter to the jury and in the Court of Appeal's decision that they were satisfied with their knowledge, if I can put it this way, of how juries work, that they would have done.
And does it matter that, I mean, inevitably you're focusing on the 10 because he didn't trust the 11th. He had the police ready. He said he had the police ready.
I accept that goes back to my answer to the first part. I accept he probably doesn't.
Does it matter for these purposes that it's effectively he's trusting a jury of 10,
yes,
and 10's not a jury within the Jury Act in Jamaica, is it?
One then gets into what I call a rather metaphysical argument about what is a jury. Clearly, it's 11 people who walk into court. And about that, I go back to what I call the first question. Is it really the case that there is no jury if it turns out afterwards that one of them had taken a bribe and was going to acquit come or may?
If it turns out afterwards?
Yes.
What if you know going in?
If you know going in, I submit the same follows. The judge is entitled to say this: a 10-1 verdict is a good verdict. It's authorized by law. I have good reason, I'm just, as it were, expressing in words what no doubt the judge would be thinking. I have good reason to trust the 10. They will follow my directions. That is good enough to satisfy the requirements of the statute, that there be a jury who decides this. Because there are 11 altogether, and if there are 11 altogether and one of them still takes no notice of what I say, well, so be it. But my Lord Audrey put the point at the beginning. It's quite a short point, but quite an important point. But I do submit the crossover between these two questions does arise, but I suppose it's very important to keep them separate. Because if I'm right in saying that a verdict by 11 men, or 11 men and women, one of whom is bent, is a good verdict at the time, then that's a good verdict. If, on the other hand, it's clear that there's a real risk that the 10 might have been influenced by the one, then I accept. That might be a basis for setting aside the verdict.
Just starting with the one, you say that the judge can choose to leave somebody on the jury, notwithstanding that he knows this person is corrupt. Presumably, it's the same if he knows that the juror is mentally ill or communicating with the deceased via a Ouija board or has been looking up the internet. It's the same, is it?
No. No, my lords, it wouldn't be the same. If I may. No. The important point here is the prosecution knows the problem. And in the passage I took you to, the prosecution says, we're the ones taking the risk.
Well, but they can't waive the public interest in the administration of justice. It's not a matter.
Well, the difficulty, my lords, if this had happened on day one, it would be a very different position, obviously.
You're really just postponing the question. So, on your view, can the prosecutor decide that it's okay to allow somebody to remain on a jury, notwithstanding all the scenarios that I've put to you, and the judge can go along with that?
In my submission, in the extreme circumstances of this case, yes.
And how many jurors can the judge allow to remain on the jury, notwithstanding his knowledge that this one's mentally ill, that one's been bribed, the next one's in touch with the deceased via a spiritualist?
Well, no, of course, he can't. The whole problem in this case arises because there were just 11 left. That is where the problem arises from. And my lords, of course, I can see one can think of any number of examples, like the lordship is putting to be saying, well, in those circumstances, surely the prosecution couldn't just waive it. But this is rather different. This is right at the end of the trial, enormous expense, 56 days, the evidence has all come out, the summing up has been done, and then boom, one thing comes out. Now, in my submission, the question is simply this. I mean, it does get to this point. If I'm right in saying that a verdict of a 10-1 verdict of 10 good people and one bent person is a good verdict as a matter of law, then the judge is entitled, and the prosecution is entitled to say, well, I dare say that person won't obey his oath, but I'm satisfied the other 10 will.
But that's assuming there's going to be a conviction. And the jury has, if it's going to acquit, is going to have to do it by, is it an 11-person jury is going to have to do it by a 10 majority. And how does the judge know? Well, it's likely that there will be 9 good people and true and 1 crook in the 10. It's an acquittal.
Well, my lord, if in my submission, the judge, the fundamental right is to a fair trial for the defendants. If the prosecution, and in one sense, this whole case comes down to one point: can the prosecution say, "I know there is this one person who seems to be offering bribes. We probably can't trust him, but I'm prepared to carry on and take that risk." Is it open to the prosecution to do that? That is the question. That's what the prosecution did. And in my submission, the answer is yes. There's no authority, if I may, with great respect, say, that says, no, the prosecution cannot do that, because that would deprive the accused of an unfair trial. I also make this point. The question is not, so to speak, at the very moment this all takes place, but looked at broadly, looking at that verdict. Have the defendants received a fair trial? If one is satisfied, the 10 were not influenced. I agree, obviously, that's a separate question. But assume for the moment that the 10 applied with their oath, they acted properly. Is it really to be said that that was a bad verdict and the defendants must be acquitted or the appeal must be allowed? I submit no. That, I do firmly say that would bring justice into disrepute. 10 people have done their duty, 1 person has messed it all up, but the verdict is a good verdict at 10-1. Why does it matter if the 1 has brought disaster? That brings the jury system into disrepute. Our learned friends, of course, rightly say that in England we don't have that problem. But this is a common law point. And the question is, what is the common law in this situation? And that's why I urge upon your lordships the point that I'm making. I fully accept you've got the separate point. Who knows what is going on in the back of the jurors' minds? That's a different point. But my point is just on this, what you might call the degree to which there have to be 11 people on the jury. The fact is there were 11 people on the jury. That is my short answer to this. One of whom, at the time, there was good reason to suppose wouldn't act properly, and who we now know didn't act properly. I submit that's not a conclusive answer. And
can I just take you to, where we got to, I think, which was paragraph 25 of the Taylor decision, page 6291.
Yes, thank you.
Lord Hope very clearly says that the direction which the judge gave in this case was clear, understandable, and to the point. And we look either earlier at what was being put forward as the defence, as the direction.
Yes.
Don't allow anyone that you sat or sitting with about some prior knowledge or feeling or view, that's unimportant. In other words, he's directed the jury to the specific problem. Now, just to say you've got to carry on with your oath seems to me non-specific. It is not to the point. It doesn't make clear to the jury precisely what the judge is wanting them to do.
In my submission in this context, it does, because they will all know there's been this half-hour break in the summing up, while form has been called away. She will have told them, because the judge says, tell the others. She will have told them what's happened. And my lord, I fully accept, of course, one might say the direction could be more forceful. I accept that. But the question is, was it sufficient to ensure the fairness of the trial, given everything else which I've mentioned? And in my submission, it was.
All I'm saying to you, putting to you, is that what was said by Lord Hope hardly supports your case, because this was not a specific direction.
Well, my lord, not express. I don't want to, as it were, quibble. I accept it was not specific, and of course, it would have been better were it this specific. But the question is, was the direction given by the judge taken together with everything he had already said, and the juror's sense of responsibility, was it sufficient? But of course, this is a different point. My submission is it was, in one sense. I take your lordship's point. It's not specific in the way this was, but in my submission it was sufficient.
I'm not sure that it. I think you probably have dealt with this point, but it strikes me when you say this is a question of common law, I don't think it's purely common law, because we do have the statutory provision.
Yes.
It's on page 6803.
Yes.
Which tells us that 12 jurors form the array in a case of murder, and then says in subsection 3, where in the course of a trial any member of a jury dies or is discharged by the court through illness or other sufficient cause, the jury shall nevertheless, so long as the number of its members, so it's a proviso, so long as the number of its members are not reduced by more than one, be considered as remaining properly constituted. Now, it might be said that the judge, as it were, can't sidestep that provision by failing to discharge somebody where there was indeed sufficient cause to discharge them. If he discovered, for example, that the person had been bribed, or was the defendant's brother-in-law, or whatever you like.
Well, in my submission, that wouldn't be the correct construction of this. In one sense, you have my point. As long as there are.
I mean, you're saying it's just a question of counting the number of live bodies on the jury, and
that's all it's saying.
Yeah.
Well, my learned friends, my submission, that's what it's saying.
Yeah.
And my lord, after all, one doesn't know. I mean, at the time the judge gives his direction, he decides what to do. He might be hoping against hope, so to speak. The miscreant juror will actually just see sense. Mm-hmm. But it doesn't follow in my submission from this act that the judge is bound to get rid of that juror. That's the question. But I agree, if he's bound to get rid of that juror, he's bound to bring the case to an end for that very reason. And this is why it is a short point, but in my submission a difficult and interesting point. I haven't addressed you on the proviso and things like that, but I'm conscious of the time. But I wouldn't mind showing you some of the evidence. I mean, it is, because I do connect it to my point. Well, there was no need for any, if I can put it this way. Anyone looking at the evidence would say, I couldn't care less about these bribes, so what? I've seen it with my own two eyes, type of thing. Forget the bribe.
Yes.
But I'm conscious, my lord, I'm preying on your time. I don't know how you want to proceed. I see what the time is now.
Well, obviously you have more time tomorrow. We perhaps, speaking for myself, yes. The point you've made about how you could find out after the event that a juror was corrupt. And the question then is if the other jurors had voted 10-1 to convict, completely ignorant of the fact that would the verdict nevertheless be vitiated, and it would have to. And I think if it were, it would be on the basis that we've been discussing, that there is, as it were, a non-quorate,
non-quorate point, really, yeah.
Which suggests it may suggest that the point we made earlier, the point I made earlier about based on. Seraphim may not be quite as obvious when you have 11 judges, as it were, as it is where you've got one judge.
As in that case.
Well, should we leave it there for the?
I'm so sorry. The case that you mentioned in Strasbourg about the racist members of the jury. Do you have the reference?
Mr. Turnbull has the reference. It's Gregory, the UK, page 7914. And I have a feeling there are two other cases which similar issues arose. I cannot quite remember. If you give me one set, sorry. Sander's one of them. Is there? And there was another one too.
There's a Russian case, which is not exactly on point, Tinkoff.
Oh yes, there's the Russian case. That's right. Yes.
8373.
At 373. 8373. Thank you.
Very well.
Sander is,
Sorry,
7960.
thank you.
Well, I think we may have reached a convenient point to adjourn for the day. We'll consider where we are in relation to the JS2 point ourselves, and we'll look forward to hearing the remainder of your submissions tomorrow, Mr. Knox.
I would like to.